Okay. Good morning, everyone, and welcome to CoPrac's meeting. As a reminder, this meeting is being recorded, and I wanted to first just start. Angela, if you could take the roll call, please.
Yes, I will take the roll call. Benola,
Present.
Bacon,
Here.
Bradley, Brown, Chivers,
Here.
Fields, Krieger,
Here.
Mark,
Here.
Mercado, Munoz, O'Reilly,
Here.
Poindexter, and Starr.
Here.
Okay. And Eleanor, I see you, so your mic is off. But Eleanor's here too. Okay, thank you.
Okay, thank you. And next on the agenda is public comments. And I know a few individuals signed up in advance, and there might be people in the waiting room. So Angela, will you call them in the order in which they appear?
Okay, just briefly make an announcement. For those who are participating by Zoom video, you should have a function for virtually raising your hand. It's a hand icon. If you wish to address the committee, please use that hand icon right now. And for those participating by phone, you can virtually raise your hand by pressing *9, that is the star key, and the number 9 to alert staff you'd like to give comment. Due to time restrictions, we can't allow more than 2 minutes for each speaker. Please note that the staff will have an on-screen timer visible to everybody. You will have 2 minutes to speak and be verbally alerted at the 30-second mark. The on-screen timer will also flash for the final 10 seconds. So first, going off the sign-in sheet, I have Kevin Moda. Kevin, are you here? Please use the raise hand function. Okay, I don't see Kevin. The next person on the sign-in sheet is somebody who has identified themselves as 5194. If you can use the raise hand function, please do so at this time. 5194, I don't have. So the next person is Lori Taylor. Lori, I see you. I will allow you to talk. You have 2 minutes, and I will give you a warning at 30 seconds. Please begin.
Thank you very much. I make this public comment on behalf of the Overarching Reproductive Law Project, which is a joint effort of Women Lawyers Association of Los Angeles and the Southwestern Law School Women's Law Association. If California adopts this new rule of professional conduct 8.3, which addresses a lawyer's duty to report the criminal activity of another lawyer, we urge that any new such duty to report should expressly exclude any act by an attorney to obtain or help another to obtain an abortion in California or another state where abortion is legal, even if that is considered in violation of another state's laws restricting abortion. States that ban or restrict abortion are moving to criminalize the of attorneys who assist pregnant women to access abortion care wherever obtained. And that includes states like California where abortion is legal. The attempt is to impose criminal aiding and abetting liability on any lawyer who helps or advises anyone seeking a safe abortion, including paying for or facilitating travel. These efforts are increasing, and we've seen them intensifying in Texas. The California Constitution in Proposition 1 makes the right to abortion and contraception a fundamental right in California. California lawyers should not fear that a new Rule 8.3 will require them to report a lawyer's efforts to help secure that right for an individual who seeks abortion care where it is safe and legal. The new rule should expressly exclude such acts from the duty to report another attorney for misconduct. And thank you for allowing me to submit this public comment.
Thank you, Lori. The next person is Reverend Frank. Reverend, can begin when you're ready.
Good morning. For those of you who don't know me, check out VanessaHolton.com. Yes, I'm one of those crazy people. Can you hear me? Okay, there we go. The timer has started. I am one of those crazy people that built the website documenting a felony committed by Vanessa Holton to the general counsel. Now, when I started reading up on you guys adopting this rule 8.3, I thought it was going to be a joke. And now I see it's an even bigger joke because everybody that's commented on there, 90% of them are all saying the same thing. I've reported a lawyer, I've talked to you guys, and I've talked to you guys, and you do nothing. So it's not just me, there are hundreds of comments out there of people who complain that even if you implement this rule, the standard that it states that it has to be a substantial or, I mean, what if a guy's a petty thief? Is that going to be enough to say that he shouldn't be a lawyer? And why should it be turned into the state bar? If I know of a lawyer that committed a felony, the last thing I'm going to do is turn it into you guys. I mean, Leah reminds me nothing more right now than that Sidney Powell whack-a-mole. And as far as I'm concerned, George Cardonas, your chief counsel, he's just Rudy Giuliani. Complaint after complaint comes into you guys and you sit there and do absolutely nothing. Now you're going to pass a rule that says lawyers have to report lawyers, but then you set a bar that really doesn't even make sense as what is substantial, what is not. If they've done a felony, if they've done a misdemeanor and the lawyer knows it, tell them to call the cops. Turn them
30
in.
seconds.
Yep, I know. So of those of you who think I'm nutsoid, check out VanessaHolton.com. I have the entire details of my state bar complaint, Vanessa Holton filing a false police report, the entire cover up. And I'm going to start a Twitch channel over this weekend coming up where I'm going to expose you guys every day that I can on the corruption that you guys face, because it's in the documents that you guys are sitting on right now. So how you guys can be corrupt and
Thank you. Your time is up. The next person we have is Andrew Tuft. Andrew, you can start when you're ready.
Good morning, everybody. Can you hear me okay?
Yes.
Okay, great. So for those of you who don't know me, my name is Andrew Tuft. I'm a former supervising attorney in the State Bar's Office of Professional Competence, where I acted as staff counsel to COPRAC for over 11 years. And today I'm speaking only in my individual capacity. And I'm calling in today to speak about the illegal contract provisions opinion. And I recognize my comment may be allayed by how you may be planning to amend the opinion during your discussion today. But in the absence of that information, I just wanted to share the following observations. And that is, in my time as staff counsel, I often strived, sometimes successfully, not always, I strive to help to find ways to achieve the committee's goals while also responding to and insulating the committee from criticism concerning any particular opinion. And in my experience, the most effective way to respond to direct criticism was to point to the law, either a rule of professional conduct, a controlling case law decision, or a statute as the basis for why the conclusions of an opinion reached were correct. And I see in your material today, you have included a recently proposed statute, Assembly Bill 747. And although I no longer serve as staff counsel to COPRAC, I couldn't help but to put on my advisor hat and call in today to encourage you all to wait on moving forward with the opinion until we see what happens with that legislation, because if enacted, and hopefully it will be, the statute can be added to the opinion as compelling and unassailable legal support for the analysis and conclusions the opinion reaches. The opinion as currently drafted comports with the policy goals of the proposed statute, so I'd expect any needed amendments to the opinion would be minor. This is an important opinion, and COPRAC should be commended for taking on such a challenging issue. And as the saying goes, discretion is the better part of valor. And if the committee chooses to exercise discretion by waiting to see whether the legislation is enacted into law, the benefit to the work and the reputation of the committee will be impactful. Thank you so much for your time. Sorry for going long.
Thank you, Andrew. The next person is Mary McNamara.
Good morning, committee members. Can you hear me?
Yes.
Thank you very much for the chance to speak. I am the immediate former past president of the Bar Association of San Francisco, and we also started a legal alliance for reproductive rights last year in the wake of the Dobbs opinion. This morning, I'm here in my personal capacity, and I want to just support the remarks of Lori Taylor. I think there are two problems with Rule 8.3, otherwise a very beneficial rule, as it applies to abortion advocacy and counseling. The first is that under the reciprocal discipline procedures in our state, This rule could expose California lawyers who are barred in multiple states to discipline here on the basis of discipline imposed in a banned state. This is more than a theoretical possibility. In Texas, for example, there is the Freedom Caucus letter that was sent on July 7 of last year to Sidley Austin, claiming that Sidley Austin's lawyers who voted in favor of compensating employees to travel to other states to get reproductive care, those lawyers were committing felonies under Texas law. If that interpretation succeeds under Texas law and there is discipline under the Texas mandatory state bar procedures, then those lawyers could be exposed to discipline here in this state. Second, I think there's a chilling effect on all California lawyers who
30
are involved
seconds.
in organizations or groups or associations that offer assistance or counsel for assistance, that somebody in a banned state might report them here. And I think that is something we want to alleviate. I think it can be easily done in a comment to the rule that excludes abortion advocacy from discipline in this state. Thank you very much.
Thank you, Mary. The next speaker we have is KK. KK, you can start your comment.
Can you hear me?
Yes.
Hi, on the 8.3, I don't think you guys should enact it because innocent attorneys will get caught up in lawsuits under 17200 as a for instance. I mean, just because they were there, they didn't report as a predicate offense under 17200. And there's many more issues that are being actually, I echo the gentleman's sentiment who spoke, and his concern was that you guys didn't address the enforcement. Well, the enforcement arm is what we're really after, and I have an issue before the bar, and everyone is waiting on the bar to act on it. It's a crime. It's a felony. It is involved in over $1 million. Or over $3 million of theft. There was a hearing today on it in court, and the judge said, you know, he's going to file a slap motion and drag this thing out. And really, when you get reports like that and it's not investigated because you're observing the rights of the attorney, and you have at your disposal the same tools, I don't think you should expand their rights to sue innocent who may be innocent under this 8.3, but because, you know, some attorney is going to take advantage of it. Some attorney might take advantage of the good intention behind this proposition and sue an attorney under 17200 or some other act as a predicate offense. But please, you guys have my papers on the other issue. I hope you guys could look at that because that is a serious issue and it's ongoing. And thank you for your time.
Thank you, KK. The next person is Angela Grijvala.
Oh, can you hear me now?
Yes.
Okay, thank you. It's Angela Grijalva, and thank you for attempting to say my name. So I'm a member of the public. I'm a paralegal who has insight. You know, I get to watch attorneys do what they do. And I think that I support the rule because I think there needs to be more accountability, not just for those bad actors, but those who sanction it by watching it and keeping silent. I'm also Latina with undocumented and just Latina within the Latino and immigrant community, and attorney misconduct is rampant. And even if they're brave enough to report to the state bar, if it's investigated, you all know that the issues there, you know, it doesn't relieve the harm necessarily, right? And so our community members will go and lose their money, their thousands of dollars. I had to help my husband. Once we got together, I found out an immigration attorney took thousands from him and did nothing. And as a paralegal, I said, look, you have the end of the week to give him his money back, or you know what happens next. And that's the only reason my husband got his money back. I don't know how many counts of other immigrants this person took advantage of. This attorney, this professional, this licensed individual, right? And how long he's been doing this. And so, no, absolutely, there needs to be accountability from within the state bar and amongst your fellow professionals. I support this rule.
Thank you, Angela. Next, we have Maria Grijalva. Maria, go ahead.
Thank you for this opportunity to speak. I am a complaining victim, and it is my, I am in favor of this regulation because specifically inside the intake unit of the bar, there are counsel that review complaints that are egregious. I'll just give you a really quick example. I made a political donation to the opponent of a district attorney. I donated to the public defender that was running. This district attorney within 90 days had me arrested falsely. And the intake attorney at the bar saw this as acceptable behavior, as normal behavior. And so there's gotta be a system where ethical behavior is not allowed. It's punished. Unethical behavior is punished, and that includes in the intake unit. So please, these regulations would be very good because inside the intake unit, there's people that are turning a blind eye to egregious conduct. Thank you so much for this opportunity to speak.
Thank you, Maria. That concludes the public comments, Sarah.
Okay, thank you everyone for your public comments and discussion of Rule 8.3 following the approval of the minutes is the first item on the agenda for those of you who would like to listen in. So right now, though, we're moving to the approval of the minutes from our January 13th meeting. Does anyone have any corrections or suggested edits to the minutes? So not hearing any, would someone like to move for approval of the minutes?
I'll move.
Thanks, Brandon. And is there a second?
Second.
I'll second.
Sorry, who was the second? I'm sorry. Or two.
Me and Joel were both seconded at the same time.
I'll third.
Angela, you're muted.
Yeah, Angela, could we do a roll call for the to approve
Yes,
the minutes then?
apologies. Okay, I'm taking the roll call, the vote to approve the minutes. Bacon,
Abstain, I wasn't there.
Brown,
Abstain, also not present.
Bradley, Chivers,
Approved.
Krieger,
Approved.
Mark,
Approve.
Mercado,
Approved.
Munoz,
Approve.
O'Reilly,
Approved.
Poindexter, Star,
Approve.
and Bonola.
Approve.
Okay, the motion carries with 8 approved.
Thank you, Angela. So the next item on our agenda is discussion of proposed rule of professional conduct 8.3. I'll just give a very brief overview and then turn it over to Brandon to discuss more. This proposed rule was issued for a 30-day public comment period. And during that time, COPRAC received, I think, approximately 84 written public comments. In addition, COPRAC held a public hearing in which 5 individuals provided public comments. And then we also, as you know, had some public comments provided at the beginning of our meeting on this proposed rule, which is now appearing on the screen, with 3 different options that COPRAC has proposed and others have proposed based on the public comments received. And I'm going to pause here and let Brandon take the lead on discussing the proposed rule and the public comments.
Thank you. I suppose I will start with an overview of the public comments received. This proposal has generated a lot of reaction. And so I've want to thank Erica for helping compile or organize the large amount of public comment we received. There were comments all over, supporting, criticizing, but I'll talk about some of the general categories of reaction. 3 commentators, 1 attorney and 2 non-attorneys, indicated the rule would help protect clients and rebuild trust. 2 attorney commentators were in support of the expanded exemptions for substance abuse and information that is shared when you're participating in a lawyer substance abuse program. 21 attorney commentators criticized, expressed opposition, calling it a snitch rule. Some of them very emphatically said they would resign from the practice of law if they were compelled to be agents of the government or snitching and things like that. 18 commentators, including 1 non-attorney, suggested there would be confusion about what would have to be reported. What constitutes a criminal act is not exactly clear. Does it impose an obligation on all attorneys to know the criminal law sufficient to distinguish, what's a criminal act or what is a misdemeanor versus a felony, things like that. Federal law, criminal law, maybe law from other states. And so that was problematic to a lot of commentators. 14 attorneys commented that this would raise the possibility for abuse. It would be weaponized in the litigation process. And half of those folks were concerned about the huge burden this would create for the office of chief trial counsel because there's going to be a huge influx in the amount of complaints for gamesmanship, civil litigation advantage, things like that. 10 commentators indicated the state bar fails to investigate the complaints it already receives. And many of them believed that this was a reaction to the Tom Girardi scandal and state bar failures with respect to the Tom Girardi scandal. But this doesn't, another rule doesn't address the fact that there were so many complaints about Tom Girardi. It wasn't a shortage of complaints. That was the problem with the investigatory process there. 2 commentators said this was unlikely to lead to any discipline and will not promote public protection. All right, so then I'll just review some of the other criticisms of the proposed rule. It could disincentivize lawyers to attempt to self-police the profession and encourage others to look the other way and avoid having knowledge that would require reporting. There were criticisms, I believe, that the rule created an exemption with respect to mediation confidentiality. Then there were other criticisms that the exemption for reporting information covered by mediation confidentiality wasn't robust or clear enough. Some believe that the rule compels speech. It will decrease civility in the profession. It will further divide the state bar and cause alienation between attorneys and the state bar. And it could create a conflict between a duty to report and a client's instruction or direction not to report. And that the failure to report in comment 6 to the proposed rule suggests that the failure to report could constitute a violation of 8.4 by the non-reporting lawyer. Over-reporting will harm attorneys, and substance abuse report information is exempted, which some criticized the exemption. Some attorneys, about 10 commentators, made substantive suggestions for changes. Some feeling that it's too broad, some feeling that it's too limited. Some suggested limiting the mandatory reporting to criminal acts that occur in connection with the practice of law, or criminal acts that raise a substantial question versus, as opposed to the reflect adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer. Some suggested that they exclude the criminal use of controlled substances from a mandatory reporting. Some exclude reporting acts of another lawyer that are harmful to that lawyer's client, which is interesting, or a duty, exclude the duty to report any act regarding the abortion, helping an individual obtain an abortion that may be in violation of another state's laws restricting abortion. We heard a couple of eloquent public comments on that issue today. I'll try to keep this moving more quickly. There were many suggestions that this rule should be expanded to require reporting of judges who engage in misconduct. Okay. Some suggested limiting the rule to attorneys licensed in California. Some to limiting it to require reporting of attorney trust violations, or exempting the duty to report where there are concerns about health and safety if the attorney reports. Adding protection from retaliation for an attorney who reports, that is similar to whistleblower protection. So some expressed a preference for the ABA model rule versus the proposed version. That was 3 attorneys suggested that although they're not in favor of Rule 8.3, they prefer the COPRAC version to the ABA model rules. 3 commented that they were in favor of Rule 8.3, but they did prefer the model rule to the COPRAC version. The Office of Chief Trial Counsel provided a very detailed and interesting comment with substantive proposals for changes in the rule, adding a timing component for prompt reporting, a revision of the language of what matters would need to be reported. They suggested removing the personal knowledge standard and returning to a knowledge standard as defined in Rule 1.01F. They suggested moving comment 3 to the body of the rule and other clarifying changes. And we also had a public hearing. There were 5 public commenters. 2 of the commenters submitted written comments as well. Some believe that crimes should be reported to the police if they are significant. Others suggested this would lead to wild goose chases against other attorneys, or could require an attorney to be a whistleblower against their employee. And we had one public comment from a person who indicated that she and her family were harmed by Tom Girardi and his firm. And she expressed support for the rule, but was concerned that there's a loophole in comment 2 for an exception for lawyers who are retained or consulted to represent a lawyer whose conduct is in question. So in the face of this very diverse, very large and robust body of public comments, the working group met and discussed and made several revisions to the proposed rule, and actually came up with 3 options that appear on your screen right now, which incorporate suggestions and principles from the public comments, and therefore our discussion today, for us to evaluate the pros and cons of each of these 3 options. They're not set in stone. They can be further, modified, but the idea being that these are sort of 3 different approaches to the operative language of the rule as to what conduct would need to be reported and how does conduct qualify as mandatory reporting conduct. We've sort of given a range here. Erica, do you want to sort of walk through these options? You want me to do that? I'm not sure how best to proceed. Everyone can see them, and they were included with the materials. Erica, do you think it would be safe to say that option C most closely tracks the Office of Chief Trial Counsel language?
Yes.
It's not perfect, but it incorporates those comments, right?
Sure. Yeah. So option A, just to, because I think there was a little bit of confusion perhaps of what the red line is. So the red line, any red line is to the originally proposed COPRAC version. So option A, the red line there is what the working group has recommended so far, based on the public comment, but again, from the version that was issued for public comment. Options B and C are alternatives instead of option A that were discussed by the working group. And then the red line thereafter, again, that's red line from what was issued for the 30-day public comment period, but is the working group's proposed recommended language. I do think, you know, in the interest of efficiency and time, it does make sense to kind of go through the rule paragraph by paragraph, but obviously, however COPRAC wishes to do so makes sense as well.
Sure. You know, maybe we look first to the red line we made in option A, right? And after considering these comments, there was a bit of a consensus that the personal knowledge standard is restrictive and confusing, maybe narrower than the public protection goal of the rule in the first instance. So that has been changed to a knowledge standard under the rules of professional conduct, which is a defined term. And we also are getting rid of this sort of like firsthand observation criteria, gatekeeping measure. So it knows of credible evidence, right? So there's, it's not a low standard, but it is loosened from the original. That another lawyer has committed a criminal act that, and this is new language, raises a substantial question as to that lawyer's honesty or fitness as a lawyer in other aspects as prohibited by Rule 8.4b. So it is still limited by the Criminal Act standard, right? And that's significant. That drew some criticism. Some commentators thought that was an excellent standard. Some think it's too restrictive. The Office of Chief Trial Counsel provided an example because they were advocating for a looser and more inclusive standard that would be broader and broader duty to report. They brought the example of, let's say a lawyer there's been a settled case and the lawyer has cut the settlement check and paid opposing counsel the settlement money, but then learns that the client of opposing counsel is making it clear through words or conduct that he or she has not been made aware that the settlement monies have been received and wants the money. So you've learned that your opposing counsel is not telling his or her client that the settlement money has come in and is not distributing it, right? That may not be a crime, but you know, per the Office of Chief Trial Counsel, public policy should want us to make that a mandatory reporting issue. And I personally found that pretty persuasive. So anyhow, that's the criminal act threshold still is retained in option A. Option B, a lawyer shall inform the state bar when a lawyer knows of credible evidence that another lawyer has committed a criminal act that is a felony or a misdemeanor committed in the course of the practice of law. So this is restrictive again, and it's restricted to a felony. All felonies, if you know about the criminal act that is a felony, must be reported, or a misdemeanor committed in the course of the practice of law. Now, this might be a great lens through which to trigger reporting obligations, but it does play into the criticisms we received that not all members of the bar are conversant with criminal law. And speaking for myself, I don't know what constitutes a felony versus a misdemeanor in different instances, right? And it also doesn't respond to the Office of Chief Trial Counsel's concern that, generally speaking, it's just too narrow. So option C was one we crafted that is a broader reporting obligation. And so there are two instances that trigger mandatory reporting. A lawyer shall inform the state bar when the lawyer knows of credible evidence that another lawyer has, one, committed a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects, or engaged in conduct involving dishonesty, fraud, deceit, or reckless or intentional misrepresentation or misappropriation of funds or property. So the idea with C was to have a broader inflow of complaints, a broader reporting obligation, and to capture specific particular emphasis on trust fund violations and that sort of mishandling. And then we were persuaded by a couple commentators, and one in particular who noted that we don't want to send the implication to attorneys who may not be steeped in the rules of professional conduct that you may only report if it's a mandatory reporting. Because as it stands today, you always have the ability to report what you believe to be misconduct. Nothing stops a member from doing that. And so we were persuaded that it made good sense to affirm that ability. And that is the red line under option C. And let's see what else here. I think those are the main changes we made. There's a couple tweaks to the comments, but they're not as material. So what we really need to do today is talk about which of these options and modifications to these options we wish to recommend. And I do think we should talk a little bit about, personally, I found, I was concerned by the comments we received on the issue of an exception for reports in helping someone obtain a legal abortion that's legal in some state, but in a violation of another state's laws. I don't know the best way to address that, but I do think that is significant and we should discuss it because I don't think that was fully on our radar as we discussed and crafted these options. So that's, I don't know how we proceed from here, but maybe we open it up, Sarah, for anyone's.
Yeah, so thank you, Brandon, for that thorough overview of the different options. And I wanted to, and I also see there's some hands raised, so I'll get to them in a minute. But the one thing I just wanted to point out, just also for background for everyone, not just on the committee, but if there's members of the public attending, is also that in addition to this proposal, there is currently a pending proposed Senate Bill 42, which proposes a version that tracks the ABA model rule, sections A and C, that is broader than the rule being proposed by COPRAC. And so I just wanted to give that as kind of background here. And I think the goal of this meeting is consider the next step for everyone, because I know some of the public comments received, there was concern about lack of adequate time to provide public comments by the 30-day public comment period in the public hearing. And I wanted to point out that there will be another opportunity for public comment, because after this meeting, what COPRAC proposes will then go to the Board of Trustees for further consideration, and the State Bar Board of Trustees will issue proposed rule for additional comment period. So I wanted to make that process clear for everyone that's attending. But yeah, I do think that the next step that we should move on is to go kind of one by one through the options and obtain feedback from the members. But I first saw Erica, you had your hand raised for a little bit. Did you want to chime in?
Yeah, thank you, Sarah. So all I was going to say is very similar to, frankly, what you just said. Just to clarify, so all of options A, B, and C are all narrower than the ABA model rule. Arguably, option C may be broader, but we can certainly talk through that. And they're all, more narrow than, frankly, any other jurisdiction has adopted. Option C is nearly identical to what is actually required to be reported in the Illinois version of 8.3. So there would be a jurisdiction that we are similar to if that option was pursued. But options A and B are more narrow than any other jurisdiction, just for those who may not be so familiar with every version of 8.3 and the other jurisdictions. That was the only thing I wanted to say. Thank you.
Thank you. And I also see Joel, you have your hand raised.
Whoops. Yeah, I'd like to talk about option B, which is what I suggested at our meeting. And I've got about 4 comments. Number one, I see this as a track, and although I would probably be in the don't adopt category, I am over in the let's see if we can add or subtract some cars to the train before it takes off. That being said, I suggested the language in option B because the phrase felony or misdemeanor in the committed in the course of the practice of law is lifted from 606805, and it is what is a conviction of which is required to be self-reported by each attorney. And I felt that that was a more appropriate standard for what needs to be reported. As far as we don't know what a felony or misdemeanor is, we all know what's in 606805. And I just think that the language of honesty, trustworthiness, or fitness of a lawyer to practice is too fuzzy, and we ought to adopt a clear standard, which is what the one I proposed, which is lifted directly from 606805. The third thing is, I too was persuaded by the comment this morning about reproductive rights. It's not something that I personally had been aware of or thought about, and I would really like to see some language that might encompass what we can add for us to consider. And the fourth comment I had was that under 17200, I'm not sure exactly how that works into this. And I would be open to having some clarification of that comment. But right now, I remain with my vote as to option B in what we propose. Thank you.
Thank you. And I see there's another hand raised, but and I'll get to that in a minute. But I just wanted to say that I also agree that with both Brandon and Joel's comments about, there were 2 public comments provided at the beginning of our meeting, and also there was a written comment too provided by the Reproductive Law Project and the Women's Lawyer Association about building in a potential comment to address that issue. But I do want to first, and I think we should get to that as part of our discussion, but I want to kind of streamline our discussion by first talking kind of in order, so to make sure we address everything with option A, and then moving on to the next 2 options to try to get a consensus on that, and then moving on to the comments. So I'll move on to Hunter now because he has his hand raised, but then I think we should start discussing option A and the revisions made to option A.
Sarah, I was raising my hand because I did want to weigh in on some of the things. There was some very lively discussion in the working group, but I think your suggestion that we kind of go through it in a more orderly manner, I'm fine doing that as well. And I'll just weigh in at the time we discuss any particular topic.
Okay, thanks, Hunter. I appreciate that. And sorry about the dog in the background. So I'm gonna, I think we should start with option A.
I think Raquel's.
Yeah, I'm looking at Raquel now too. I was just gonna, so Raquel, if you wanted, did you have a comment on option A that you wanted to?
No.
Oh, okay.
I don't.
But do you
I don't
another
have
comment?
I have an overall comment, which is, I realize you're suggesting we go A, B, and C, but there may not be a need to go A, B, and C if people have coalesced around one or two. So I realized maybe from a process standpoint, automatically saying, let's just go sequential, maybe having us work ground not necessary. So maybe just kind of having a sense of where people are generally, and then that would help us focus on, oh, here's where we should focus. So it's more of a process suggestion at this point than making any particular commentary.
Sarah, you're on mute.
Sorry. Thank you, Raquel. Yeah, so I think I want to start with the black letter law being proposed first, then move on to the comments. But if we want to kind of get a sense first, I think to see what members of the committee are thinking, kind of like not a vote, but a straw poll on each of the options. And then we can kind of maybe, like Raquel suggested, I think that's a good idea to start with the discussion and maybe the option that most members are interested in. So I maybe Angela, if you could take a straw poll. And I want to also point out that what we present to the Board of Trustees does not necessarily have to be option A or B or C. Another alternative that we could do is suggest option A or another option if the Board of Trustees elects not to go with option A or whatever I'm just giving that as an example, but whatever our consensus is, we can make it clear that COPRAC as the committee recommends that the Board of Trustees consider option A, B, or C, whatever, let's say A as an example. However, in the event the Board of Trustees elects not to go with option A, or the alternative would be option B or C, whatever we decide on. But I would like to get an idea of which option members are leaning towards. And Ken, I see your hand is raised.
Yes, I just want, before we do that. So this is it, A, B, or C? There's no possibilities of a D or some other options? Because I think all A, B, and C all have issues.
I think we can certainly discuss that. But I think we should start with the A, B, and C, which the members of the working group have worked on. And option A closely resembles what went out for what went out for public comment with the redlined edits. So I think we should start with that as a priority, but we certainly can open the discussion to a potential alternative.
So Sarah, when I take the poll, I'll just have each person indicate A, B, or C in the straw poll.
That sounds great. Yeah.
Okay, so I'm going to do that right now. Bacon,
Can I say none of the above? If I'm limited to A, B, and C, I'm probably leaning B. But I'm
Brown,
more than none of above.
A very resounding B that is.
Brown,
Angela, did you, Brown, none of those, one to be determined.
okay. Bradley, Shivers,
A.
Krieger,
C.
Mark,
B.
Mercado,
B.
Munoz,
B.
O'Reilly,
A.
Poindexter, Star,
A and B in that order.
and Manola.
A.
So I carried the day with C.
One count up. Okay, so we have 3 for A, 5 for B, and 1 for C.
My count with Hunter picking A over B was tied 4B and 4A.
All right, so we know it's A and B. No one seems to be going for C. One person.
But a really important person.
I appreciate that.
Well, we're not making a judgment on
No.
the value of the way people voted how, just the numbers. It's
So-
just the
Let's rank the
numbers.
committee members in
So we're
order of
not-
importance.
Right.
I fully respect that we should spend our time in A and B here. I just will point out that the example that the Office of Chief Trial Counsel gave in that in their public comment, I thought was really powerful. The idea that the other attorney is doing something wrong with settlement money. But you don't know that it's a crime. I don't know if it's a crime yet. Now, obviously, I think all of us on this committee would voluntarily report, but I was persuaded that that would be a good instance of a mandatory reporting that does not fit within the criminal threshold. But I won't comment on that further. And we should probably, I guess, focus on A and B, which is fine.
Yeah, and Brandon, just as one issue that I am concerned about as we go through these options as well is just based on the public comment too, and the fact that there is a proposed Senate bill that is much broader than option A or option B, is that there is a risk if it's too narrow. Because we have to consider the parallel proposed bill as well. And there were significant public comments that were concerned about it being potentially too narrow. So I just wanted to point that out. But I do think we should focus right now on, maybe we can go in order since they were tied, starting with option A, discussion of option A. But Dan, I see you have your hand raised.
Yeah, I mean, if we're ready to start talking about it, I think I'm enticed by the idea of B tying it to the existing code, because that's always helpful. But for the B proponents, do you interpret that committed in the course of the practice of law would exclude something that they did in their personal life? For example, fraud. What if somebody committed insurance fraud? Would that be excluded from your reporting requirement?
Yeah, I mean, this is exactly what a conviction requires self-reporting. And if insurance fraud not committed in the practice of law is only a misdemeanor, it wouldn't be reported according to this language, but that's what 6068E05 says. And if I can respond also to Brandon's concern while I was listening to it, and a good concern it was, I would think that a stealing or failing to give a client trust funds which are owing would be at least a misdemeanor committed in the practice of law. But if that's not clear, then we might add felony, misdemeanor committed in the course of the practice of law, or a violation of the rules of professional conduct to be. So that's how I'd address both questions I've heard so far.
If I could weigh in, one of the major differences between 1 and 2, or A and B, is obviously this idea of distinguishing when it comes to certain designated crimes, right? Misdemeanors. The option A is broader because it would include any misdemeanors. My background is, of course, criminal law, and I don't want to suggest that I'm weighing in terms of the wisdom of laws that have been passed in California regarding this. But it's important to note, with the concern that we've had in public comments, and frankly, with the concern that the committee has had with, well, not everybody's a criminal law scholar. This question of raising a substantial question, I think, deals with, well, is it a crime versus is it not a crime? If you see something and it turns out it's a crime, but it never raised, I mean, If you see something and it raises a substantial doubt, that's the first indication that it's probably a criminal act. If you see something that's a criminal act, but you wouldn't know it's a criminal act, then it's probably not the type of thing that's going to raise a substantial question. So I think that modifier really takes care of the issue. Is it criminal versus is it not criminal?
I don't think that's how it's drafted, Hunter, though. I mean, at the moment in A, it has committed a criminal act first.
That
also-
raises, yeah, that also raises. And I think, but the question of, well, not everybody knows what the criminal law is. I think the issue there is they're worried that they might miss something and then they're on the hook for not reporting a criminal act.
Or they report something that is not a criminal act, as Brandon's example suggested, that somebody just was on vacation. They didn't disperse the funds.
Well, what I will, okay, I mean, these are valid points, but what I was getting to was that the distinction between felony and misdemeanor is far more confusing than the distinction between something that is or isn't a criminal act. I mean, take, for instance, when somebody sees something happen on a street corner, they call 911. Is it possible that they're calling on something that's not a criminal act? Yeah. But the reality is crimes are generally going to be tied to something that the average person can tell shouldn't be happening. And as attorneys, we're probably more likely to recognize that, seeing as how we've all, passed the bar, studied criminal law to some extent, even if we're not scholars in that area. Whereas distinction between felony and misdemeanor is far more complex, especially post Prop 47. Prior to Prop 47, if you stole a car, that's a felony, plain and simple. Now we have a valuation issue. If you steal a car from that's $900 car, there are plenty of cars that are operable driving around that are not worth over $1,000. That's a misdemeanor. Whereas when you're convicted, it's easy to tell the difference between felony and misdemeanor because the conviction is for either a felony or misdemeanor. So I like the idea of mirroring 05, but at the same time, the commission of an act versus the conviction of an act, that distinction between felony and misdemeanor is far more difficult to discern. Second of all, we criminalize as misdemeanors some frankly very egregious conduct now post Prop 47, because pretty much all theft crimes were rendered misdemeanors if the stolen value is under $950, which is frankly most of the stuff that can be stolen in person. So used to be if you stole a gun, that's not just a felony, it's a strike. Now, I mean, take for instance, your typical Glock is going to be $400 to $600. You steal a Glock from a store, misdemeanor. So that distinction, I think, when we're talking about commission, that is going to get more technical than really the rule should cover. On top of that, we talk about the breadth of what we're discussing. B is narrower. And generally speaking, I'm in favor of a narrower rule because our process as attorneys, we're inherently adversarial. And so I think we should have a narrow rule so the entire practice of law does not become about this. But I think in terms of the confusion that may be raised between felony and misdemeanor is legitimate, whereas I'm not concerned so much that people can recognize a crime from what's not criminal. So I'm in favor of a narrower rule, but I think that B is too complicated and too narrow, because if you saw an attorney steal, just walk into an AM/PM and steal stuff and walk out, I think that that's that's something that should be reported, but would not be connected with the practice of law. A fraud, the theft of a crappy car. These are things that would be misdemeanors that I think any one of us would say, no, that needs to be reported. That's the kind of behavior that needs to be reported. You're at a party and you find somebody you know to be an attorney using heroin. And now maybe that's something that they need to get help on, but to just turn a blind eye to it and walk away, that may be a problem. So I like the idea of option A because I think it strikes the proper balance. And I'm using up everybody's air, so I'll finish with that for now.
And I just have a follow-up kind of clarifying question relating to Hunter's comment, and I'll get to some of the hands raised. But so I don't necessarily read option B as requiring the attorney necessarily to make a distinction between a felony or misdemeanor, because it seems to require the reporting of either. The question I had though is, it says criminal act that is a felony or misdemeanor. And maybe Joel, you mentioned, and I see you have your hand raised too, that this option is based on Business Professions Code subsection O. And is that the subsection that requires self-reporting when there's been an actual conviction of a felony or misdemeanor? So there's no actual confusion there as to the standard. Is that, could you clarify that, Joel?
Yeah, that 606-805 is what you have to self-report if you're convicted. And obviously, nobody who's going to be reading this is going to know if there's going to be a conviction. But if tying it to credible evidence, it seemed to me that you'd know that when you see it. And if it could lead to something that would require the attorney himself or herself to have to report it, that's when you should be reporting it. And so that's why I adopted the language. And I just want to say in response to Hunter, I agree that since the only misdemeanors we're having to distinguish are those committed in the course of the practice of law, I don't see how any of us, or should I say, I don't see how the vast majority of us attorneys are going to be confused about whether stealing bubble gum from the store is a misdemeanor or a felony.
Just for a brief response to that, because if you see a crime, you have to determine, is this a felony that I have to report outright, or do I have to determine if it's a misdemeanor? Because if it's a misdemeanor, then I'm only required to report if it's in the practice of law. So I kind of agree, but if you see something in the practice of law, then it doesn't matter whether it's a felony or misdemeanor, you report it. That makes it easy. But if you see a crime outside the context of the practice of law, then you have to do that analysis. And I don't think everybody's equipped to do that analysis. And I think at the end of the day, because you're permitted to report criminal conduct either way, that frankly may take care of the issue. But I think you would still, once you're treating felonies and misdemeanors differently, at the end of the day, you're going to have to know the difference.
Yeah, Hunter, accept this comment with my tongue firmly in cheek. I think you've just proved why only people who practice criminal law are going to get confused.
And Hunter, I actually realize I'm reading, I think I may have misread option B. So is the intent of option B, this is a question for, I guess, for one of the members of the drafting subcommittee, to only report any felony regardless of whether it's in connection with the practice of law?
Yes, that was my understanding.
Okay. Okay. So now I understand Hunter's comment more. So thank you. And Brandon, you also had your hand raised. Did you have an additional comment you wanted to?
Yeah, I'm finding myself very persuaded by Hunter's explanation for why option A is less confusing than option B. And I just wanted to point out that there's a certain appeal, as Joel mentioned, the fact that these are the standards in 606-805. But I do still have a concern about the burden on each lawyer who's already got, a lot of obligations in the practice of law. That's the self-reporting standard. And hopefully in the career of a lawyer, they are never convicted of any crimes. But if you are convicted of a crime, if I were convicted of a crime, then I would have an obligation in that instance to figure out the difference between a misdemeanor, felony, and that might be a really tough obligation for me as a non-criminal law practitioner. But now, if we were to adopt B, now every attorney in the bar has that obligation anytime they see something improper being done by another member. And so I do think, for these reasons, and I'll just cut it short, I am persuaded in favor of A as between the two. That's it.
Thanks, Brandon. And Ken, you've had your hand raised for a while as well. Did you want to weigh in?
Yes, I do. Where to begin here? Both A and B say the lawyer must know. Know is defined in the rules as having actual knowledge, or it may be inferred from the facts. So that, to me, kind of gets to a gray area right there. I was curious because we've got credible evidence in here, what actually that means. So I did some quick searching on that, and there are multiple different definitions: Black's Law, law.com, case law, what credible evidence actually means. So that's unclear too. When we get to the committed a criminal act, that raises many questions which have already been addressed. What is a criminal act? Are we referring to penal code, B&P code, health and safety code sections, any criminal act, a criminal act under California law, a criminal act under laws of another state? It gets into all that. Then we cross-refer at the end of A to Rule 8.4B. But if we're getting into 8.4, the comments to 8.4, comment 3 says, a lawyer may be disciplined for criminal acts as set forth in the Business and Professions Code, section 6101 exsec, or if the criminal act constitutes other misconduct warranting discipline as defined by the California Supreme Case Law, see In re Kelly. So if we're incorporating that whole mess into what is a criminal act, what is not a criminal act, what is covered by Rule 1.4, does that include all the stuff under BMP 6101 exsec? I don't know how any lawyer is going to understand that. And then once again, the question of what is a criminal act and what the lawyer knows is, just hypothetically, let's say I'm out having dinner with my wife and I see a lawyer I know at the same restaurant. And during the course of dinner, I noticed that lawyer has 4 glasses of wine. And as that lawyer's leaving, the lawyer stumbles just a little bit, but who knows? Maybe the lawyer tripped. And I see the lawyer go outside and get into a car. Hi, Dove. My granddaughter just entered the room. Do I now know? Do I have credible evidence that that lawyer is, driving under the influence and committed a crime? Do I have a duty to report that? I mean, this is just such a vague, overbroad can of worms. That's why I was wondering whether, if we're stuck with A, B, and C, and why not just stick with something more similar like the model rule, where they've committed a violation of the rules of conduct instead of getting into criminal act. So the credible evidence issue, what that means and what knows means and what's a criminal act, that kind of goes through all A, B, and C. That is my concerns with all of these options.
Thanks, Ken. And I was gonna turn it to Erica, who's had her hand raised. And Erica, in addition to providing the feedback you had, the one issue that I thought might be helpful based on Ken's feedback to describe would be how this edit was made from personal knowledge to credible evidence, because my understanding is that was based on public comment of Kevin Moore. And I think it's also similar to historically when the Rules Revision Commission has considered a version of ABA Model Rule 8.3. So if you could provide some insight on that, I think that would be helpful too.
Sure. So I'll actually speak to that first, and then I can address what I was going to raise. So the nose of credible evidence is from the public comment received by Kevin Moore, who was on the prior Rules Revision Commissions, but it's actually derived from the Special Duties of Prosecutors Rule 3.8F, as in Frank, and which says that it requires a prosecutor to take certain action when the prosecutor knows of new, credible, and material evidence, creating a reasonable likelihood of something, in this instance where a convicted defendant did not commit an offense. So the thinking there was that the credible evidence standard was higher than the just plain nose standard. Relatedly, you could add the reasonableness threshold that exists in 3.8 to this rule. I'm not sure how much that would actually frankly modify it, but that's something that could be considered as well. So it could be something along the lines of knows of credible evidence, let's see, that there is a reasonable likelihood another lawyer has committed a criminal act, etc. Again, that could make it perhaps more vague, or it could clarify it depending upon your interpretation. What I raised my hand for and to speak to was Brandon's comment about his concerns with the failure to that a trust accounting violation without knowing that it's a criminal act may be a criminal act, but you just may not have enough information in that instance. And that was raised in the OCTC example, but there was also another individual who gave public comment with concerns about trust accounting violations that may not be criminal acts, or you may not have the knowledge to determine whether or not they're criminal acts. So an option that could be added to A would be to limit the rules violations to being some version of a violation of 1.15. I'm not sure the committee would want to do that. And if they did, I'm not sure you'd want to have every violation of 1.15, like perhaps it's, misappropriation commingling, as opposed to, the duties to properly, reconcile your trust account and the record keeping obligations. But that may be something to consider to address that concern that was in OCTC's comment, as well as some of the others that we received.
Thanks, Erica. And
Can I just follow up on that one bit? Because I did go now look at 3.8, which says credible evidence or credible or material evidence. I get back to what does that mean? Like I said, I just did some quick research on it, and I saw at least 4 different definitions of credible evidence. So I'm not sure if we're going to have some sort of standard on reporting, and it's unclear what exactly is credible evidence, much less it's evidence that, knowledge that can be inferred. I just see problems in enforcement with that, or how do you follow up on that? Because it's so vague.
I share that concern.
If I could weigh in on 2 of these comments, that's why I don't want to have us go with reasonably knows, because to parrot on Ken's example, suppose in the restaurant he was bending down when the fellow stumbled, and somebody says, well, you reasonably should have not been bending down and you should have seen that. I want to go with a stricter standard of and so that's my comment there. And as far as the rest of the stuff with the problems of what's a criminal law, what's a felony, what's this, what's that, and what are the definitions of reasonable evidence, credible evidence, and all that sort of stuff, that's just a problem with this whole reporting thing. And California is a minority of one, and we're not going to get out of this thing by all the confusion that it causes. The best we can do is try and get some really bright line standards as opposed to the more fuzzy ones. And so that would be my comment to the 2 I've heard so far. Oh, and a third thing would be to add rules of professional conduct violation is something, but we can consider that other time.
thanks, Joel. So the other, because I don't see any other hands raised, as we're considering these options, I do want to point out, because both Ken and Joel raised adding rules of professional conduct, a violation of the rules of professional conduct. I want to point out that option A, if we, there's some language that's similar to the ABA model rule, but the ABA model rule that, as Ken pointed out, does, is limited to the rules of professional conduct. And I think COPRAC's initial proposal in referring to a criminal act was intending to make the obligation narrower than the ABA model rule. There was some discussion earlier about the language raises a substantial question as to that lawyer's honesty, trustworthiness, or fitness. I know Hunter provided some feedback and felt that language was helpful. And the other reasoning for this language raises a substantial question as to that is that that's used in the ABA model rule and other state versions of this rule. And it's intended to reflect that just not every single criminal act would require reporting. It's one that has to be serious enough. And that is responsive to a lot of the public feedback where they felt that, the reporting should be limited to a criminal act that is serious enough that it should be reported because it raises a substantial question as to the lawyer's honesty, trustworthiness, or fitness as a lawyer. So I found that addition helpful to option A. And I do share some of the concerns raised just about option B about felony or misdemeanor and that being perhaps an unclear standard. So I will pause here because I know that several have weighed in, but I want to see if others want to raise comments about just option A or option B.
Can I ask one follow-up question? Because, because Joel mentioned how, we're, a minority of one here in California. I mean, I did look at the model rule, but other states that have this type of a rule, but don't necessarily follow the model rule, do they address criminal acts? Because the model rule doesn't. It's really focused on the rules of conduct as opposed to criminal acts. So I'm curious of other states that have something other than the model rule, how many of them focus on criminal acts as opposed to rule of conduct violations?
I can answer that to a certain extent. So Illinois is the primary jurisdiction that focuses on criminal acts. It is essentially what is contained in option C. So what they do is reference a violation of 8.4 Rule 8.4B and 8.4C, which 8.4B is essentially what is contained in option C1, and 8.4C is what's contained in option C2 as far as the obligation to report. The ABA model rule includes a violation of any rules, which would therein include 8.4C and 8.4B. So you are already required to report those things under the model rule, meaning a criminal act that, reflects adversely on the lawyer's honesty, trustworthiness, fitness. So those things are within the duty, what you must report under model rule 8.3.
Wait. What bothered me about the fitness as a lawyer language in A was reflecting back on our discussions about a rule on civility. And what can of worms does that open up when somebody considers a rude act in a court or something, or outside the courthouse steps or something, to be lack of civility, and I don't think that person should be practicing law because they're too rude or they're too uncivil or whatever. And fitness as a lawyer, you talk about definitions that you can drive trucks through. That is one of them. So that's what really troubled me about that, just in reference to the civility issue, but it probably would reference a lot of others. And I would rather have to worry about distinguishing between what's a felony and a misdemeanor committed in the practice of law than what is fitness to practice law. Because, you know, having fielded now about 40 state bar complaints as a special deputy prosecutor, special deputy trial counsel, there is a wide variety of opinions among the public as to what constitutes a lack of fitness to be a lawyer.
Thanks, Joel. And just very briefly in response to your feedback, and then I was going to ask Raquel to weigh in because she's had her hand raised. You know, the way option A is currently drafted, it's a criminal, it has to be a criminal act first. And then it's one that raises a substantial question as to the lawyer's honesty, trustworthiness, or fitness. And I understand that language has been used, is part of the ABA model rule and other state rules. And I just had a quick follow-up question that I wasn't able to raise based on Erica, what you were saying is, my understanding is that other states, well, they don't necessarily use the term criminal act, they do refer to their 8.4, Rule 8.4, which does use the term criminal act. Is that what you were saying?
Yeah, so the only state that has, I have the model rule comparison chart up, the only state that limits it to criminal acts is Illinois.
Okay.
So, and that they don't use the phrase criminal acts, they cite to 8.4b, but every other state also requires you to report a criminal act because every other, or not every other state, but every other state that relies on the same language in paragraph A of the model rule, you know, 8.4b violations must be reported, and that is a criminal act.
Okay, thank you. And Raquel, did you want to provide some feedback?
Question and comment. I have a question, I think, maybe to Erica or to you, Sarah. What is going to be the implication of what we're doing and the Senate Bill 42? Should they be on taking divergent paths?
So I think I'm not sure exactly what the what will happen with the Senate bill and the legislative process. I understand it will be considered in sometime in September. In terms of our process, COPRAC would like to recommend, my understanding of one of these options, or perhaps two of these options, for the Board of Trustees to further consider. And the versions that have been proposed have been so far different than what is being proposed as part of SB 42. SB 42, as I mentioned, closely tracks the ABA model rule. And based on discussions at our prior COPRAC meetings and based on some of the public comments, although some do favor an ABA model rule, I'd say more of the comments and members of our committee seem to be weighing in favor of a narrower version of the rule. So I think our kind of task here is to propose a rule for further consideration by the State Bar, real professional conduct. And it may be that as part of the consideration of SB 42, they decide to defer to if there is an established rule at that time. That could be, you know, I'm just speculating here. That could be one thing that happens, is that SB 42 is not adopted as a result of, you know, of real professional conduct that is adopted first. Or, you know, I can't really predict exactly what will happen in response to your question. But I think just in terms of our goal is to propose a rule that COPRAC finds is reasonable to potentially adopt as a disciplinary, or recommend for adoption as a disciplinary rule.
Erica, do you want to add anything before I?
Sure. I mean, so what Sarah said is exactly right. So the reason this has been expedited in part is so that you know, the legislature can see what's going to be proposed by COPRAC and the Board of Trustees, and look at that and determine what they want to do with Senate Bill 42. If they want to continue with what's proposed, which is essentially the duty to report that reflects ABA model rule 8.3 paragraph A, if they want to make modifications to that, or, you know, take any action that the legislature frankly feels is appropriate. And that's all. And that, so there's the possibility exists that there could be two requirements. There could be the requirement that exists in the Business and Professions Code if Senate Bill 42 is ultimately enacted, as well as a requirement within 8.3. There are other instances where there is a statutory obligation that is either parallel to or different from an obligation within the rules of professional conduct. A great example of that is, you know, 1.6, which is the duty of confidentiality, and 6068E, which is a statutory obligation related to the duty of confidentiality. In the prior versions of the rules, you know, those weren't necessarily identical, so you would always have to look to both. 1.6 now describes and cross-references 6068E. So lawyers are required to look to both of those obligations when dealing with confidentiality issues. And that's, you know, beyond attorney-client privilege. So that is a possibility that could occur here. I'll just, you know, my personal thought is that that's certainly more likely the narrower, whatever COPRAC or the board's 8.3 looks like, right? Anything that's the narrower it gets, in my personal opinion, and I, you know, I can't predict anything, the more likely it is that there is a version of Senate Bill 42. But again, that could happen regardless of what is proposed by this committee and the Board of Trustees.
Okay, thank you. For me, I think that's important. I mean, because my sense would be the state bar would prefer to have something that doesn't necessitate the Senate putting something in that's more strenuous or rigorous, whichever the word you want to use. So that was the basis of my question, was to sort of understand how what they're doing is maybe impacted, and how what we do, we should be aware of that, because it should be our goal for them to drop Senate Bill 42, would be my sense of it. So we should maybe stretch more than we'd want to, because the alternative is that it gets even more it gets more, like I say, it raises the bar higher. And then if you have to have two things that people are trying to worry about, it in some way negates having a role, because people will more than likely ignore it because it just becomes too much. So that's sort of just on the procedural. I realize as the more I've been listening that I thought that option B is limited to behavior in the course of practicing law. But then something Sarah said, and all of these other examples, which are now talking about, I saw someone do something at a restaurant, or someone committed insurance fraud, is not in the purview of the practice of law. So I realize that perhaps in the course of practice of law in option B is not that narrow. So that's a question. Is it that narrow, or is it not that narrow?
Raquel, I'm happy to respond to that question, because I had the same confusion based on how it's drafted. And that was the question I had raised earlier. So the way I understand option B, and Brandon, you can correct me because I think you clarified this for me earlier, but so for option B, the criminal act that is a felony does not have to be in connection with the practice of law. However, a criminal act that is a misdemeanor has to be committed in the course of the practice of law.
Yeah.
So I had read it as modifying both, but it actually, in the course of the practice of law, is only intended to modify a criminal act that is a misdemeanor.
That was my understanding of our intent. At least
Sarah,
my understanding.
my last comment at the subcommittee was to insert the comma after felony to try and make that more clear that the or did not appear as to both felony and misdemeanor when referring to in the course of the practice. If there's some other way we can clarify that other than my comma, I'm fine with it, but that was my attempt.
The addition of the comma did seem to implicate the rule of the last antecedent, and I think when you read it like that, I don't know that it's going to be confusing to everybody, but it certainly has confused enough people that we should probably look at the drafting of it.
Yeah, I mean, it could be potentially addressed in a comment clarifying it, but
So I have a follow on and I'll direct it, I think, to Brandon. So why the distinction that a misdemeanor is only related in the practice of law, but a criminal act, besides the rule that already exists about criminal acts? Is that the reason?
My
Okay.
understanding is the idea is to try to not have a flood, you know, sort of like limit it to really significant stuff, which is every felony is really significant. And not all misdemeanors are significant enough to mandate reporting, but if they are misdemeanors in the course of the practice of law, you should report. That was my understanding of the.
I don't want to debate
Thank
which
you.
misdemeanors are and all that kind of stuff or how serious they have to be, but 6068E05 is what an attorney would have to self-report if they were convicted of it. I don't want to have all the attorneys in California have to report people for something that they wouldn't have to report themselves.
I think that's a really good point. I would love to see an option B2 that just took out the language that is a felony or a misdemeanor and just went with criminal act committed in the course of the practice of law if we were going to do this. Or I generally agree, which I think this is just overly broad. It raises a lot of questions about, you know, whether you have to report if there's already legal action, you know, if it's, I just don't see why we should be in a position of having to do those reports, especially if there's police involved, et cetera. It seems like overreach to me.
And I think that in terms of, Joel, your comment where somebody would have to report somebody else for essentially something that person would not even have to report themselves. I think that's a poignant comment. And that's why we have the limitation of something that really reflects on the lawyer's honesty or trustworthiness. And I think, of course, if we do end up with a rule like the model rule, we will have far more duties in terms of what an attorney would have to report. And that does bring up the question that we were talking about earlier, which is it our goal to kill the Senate bill? I wouldn't say it's our goal to kill the Senate bill. I would say it's our goal to beat them to the punch with a more effective rule that is more balanced and takes into consideration the realities of the practice of law. And to the extent that we have to do that, I think the consideration of the Senate bill should be something we're aware of, but not an ultimate goal of the writing of the rule. That's my 2 cents on it.
Thanks, Hunter. And Cassidy, did you want to weigh in? You've had your hand raised.
Yeah, just 2 quick comments. I think this is all well covered territory. I'm still in favor of option A. And I wanted to point out that if we are proposing option A, including the language about substantial question, that there should be also, I think it's important to have the same comment that the model rule has, comment 3, that defines substantial question and what that means. And most importantly, and I think this kind of addresses the issue of, you know, how does a lawyer figure out, you know, whether they can report? Because I think the definition of substantial question builds in kind of a safe harbor, because it says that that there's a measure of professional judgment involved for a lawyer, so that if they are, you know, if there is some question of whether or not they should be disciplined for failing to report, they can come back and say, well, in my professional judgment, I did not think this rose, you know, to the level of it was a substantial question. And I think that provides comfort, you know, when lawyers are weighing whether or not to report. And then, you know, as far as option B, I think everybody's kind of danced around or basically said what I was gonna say, which is, I just think it's too narrow for it to, I think it's gonna be too narrow and that the Senate bill will then be adopted. So I think that, I like it because it's narrow. But I just don't, at the end of the day, I think that it's probably going to be too narrow for it to be, ultimately passed.
Thanks, Cassidy. I share those concerns as well. I even have some concerns that perhaps even A is too narrow. But I want to turn it over to Cassidy. Were you done with your? Did you have other feedback before I turn to someone
No,
else?
I just want to make sure that if the comment 3 does get incorporated into option A, an option A proposal.
Yeah, and we should definitely consider that when we turn to the comments, which I'm hoping we'll get to after the lunch break. So Eleanor, did you have some feedback as well?
Yeah, I guess, I mean, I shared my general view. I understand people have varying concerns about these, and we're trying to do something that'll be effective as well. But I wonder if we shouldn't also include, as much as I am not, I don't like any of these alternatives. I'm wondering if we should include firms as well as lawyers, and because firms can act through non-lawyers, so I think that might get to the spirit of it.
Do you mean a lawyer shall inform that another lawyer or law firm has committed a
Yeah.
commitment or whatever?
Yes.
Can I just add one comment about the threat of what the legislature might do? And I think as a body, whichever one of these options or some modification thereof or an option D proposes and thinks it's best, I'd rather be run over by the train and state our point of view than to not and cave in. And frankly, I don't want you to take this comment to think I don't think this rule is important, but based upon all the comments when this was beat up on the APRL listserver about 3-4 months ago, the best anybody could point to was at one case in Tennessee where a lawyer was the subject of discipline for failing to report, and that was only because apparently the lawyer reported an opposing counsel in the press before they reported it to disciplinary counsel. And disciplinary counsel was pretty pissed off by that. So the chance of this ever really happening in some way, if it hasn't happened in the other 49 states, but one time or 2 or 3, I'm not all that concerned. And that's just one more reason why, if we're going to state our opinion, I would rather state what we think would be the best rule, and not just say we're going to cave into what the legislature is going to do if we don't. So I'm done.
Thanks, Joel. And one thing I think I've pointed this out, but in response to that particular comment, I do agree that what we ultimately propose to the Board of Trustees for further consideration, we should present what COPRAC believes is the best option. However, we could still consider presenting an alternative for their consideration. That is one way we could proceed as well. And Cassidy, did you want to weigh in? I see your hands raised. I don't, maybe it was still raised from last time, so I'll turn to Hunter.
I would like to echo Joel's comments with regard to what our goal is, and our goal should be the best rule using our expertise.
Okay, so I think we've had a lot of feedback on options A and B. I'm going to suggest a path forward before the lunch break, but now that I see Raquel has her hand raised, I'm going to turn to Raquel first.
So in having heard a lot about A and B and no one voting for C, which I understood was the recommendation from a council, it seems that I think the only difference in C and A is the addition around the money, number 2. Am I not reading that correct? Basically, I mean, it doesn't have raises substantial questions, et cetera, et cetera. It's just pretty straightforward. And so
I view that the same way.
I'm sorry, would you say, Sarah?
Oh, I was just agreeing with you. You
Okay.
Question.
So that then raises the question, I guess, to the committee: what is the opposition to including 2? And I did hear Brandon give a number of times the the comments that would lead us to be influenced to say yes. I realize I haven't heard why people thought that would be an issue. I personally did not find an issue with it. I thought it speaks to probably one of the largest areas of complaint, and particularly when you look at the non-attorney public comments, theirs was more around number 2 than anything. So it certainly seems like the public definitely feels that they are being harmed by lawyers' behavior that's characterized in number 2. So I'm interested to hear from the committee why the opposition of the number 2 around the client funds or property. Because to me, based on the dialogue, as I've said, the only difference from C and A is that number 2. Over.
I can add some feedback if you'd like. So when I see option C, particularly number 2, I can tell you that on a daily basis, opposing counsel lies to my face, or recklessly misrepresent every single day in negotiations. And the thing is that's just a part of the type of law that I practice, and I accept it. There was a jury trial that I was in a couple of years ago. It lasted 3.5 months, and there was an allegation that I hadn't turned over a certain police report. The attorney making the allegation plugged in a thumb drive that he'd received in discovery, pointed to the list of documents and said, "See, nowhere on there is this report, and therefore this is misconduct." And I said, "Judge, it's literally right there on the screen." And I pointed to it. So the argument that it wasn't provided was either a deliberate misrepresentation or a reckless misrepresentation. But the fact is, I should not have had to report that attorney for that reckless misrepresentation. That should be dealt with in the trial court in the context in which it is being done. This covers so much that you would end up, if it was actually followed by attorneys, with what you might call an embarrassment of riches, where every single litigation, every single case would become, much like attorneys' fees become the center of every case, would become about lobbing complaints at one another over perceived misrepresentations. Now, I think that misappropriation of funds and property, that's something that would be problematic. That's something we can address. But when I read this, it just, dishonesty, reckless or intentional misrepresentation. We use that in closing arguments all the time. Look, they just misrepresented this. That's not the law. That's not the facts. I mean, how detailed are we going to get here? Because we're an inherently adversarial system. And I understand, because I deal with victims and I see defendant families in my line of work, both sides think the other side's lying and think the other side's trying to harm them. That's the nature of the practice. And so the public is always going to feel like it's lawyers in cahoots with each other, because these are very highly technical and nuanced rules that we deal with. So I appreciate the concerns that they have, but at the same time, I don't think it's realistic to enforce some of these when you're now making it the opposing party's duty, not just option, but duty to report it. So now, instead of looking at it and saying, look, that's just part of the litigation, I'm going to take it in its due course. Now I have a duty where I am committing misconduct if I do not report it. And that can spin out of control so fast. So that's my primary concern with 2, not misallocation of funds or property. I don't have any problem including something about that. But that first part of C2, I see as being a real problem.
Thanks, Hunter. And I do want to point out that option C, the subsection 2, that language, I think Erica might have mentioned this before, but it's taken from 8.4, I forget what subsection C maybe. That language, but I had a question for you, Hunter, just based on your comment. Would you, if there were some kind of more limitation built into 2, such as the substantial question as to that lawyer's honesty, trustworthy, or fitness as a lawyer added to the end of subsection 2, would that make you kind of any more comfortable with that standard?
It would allow for discretion on the part of the party that is being required to report it, but it does not deal with the not just possibility, but eminent likelihood that the rule will be weaponized in litigation. So it would make me more comfortable to modify it with the professional judgment, as Ms. Chivers was saying earlier, but
Yeah.
I would still not be comfortable with that rule, because weaponization of the rules is a true danger, and it's one that will hurt the public, because it's going to hurt clients on both sides of any adversarial litigation. So weaponization of the rule is still a big concern.
I agree with that. I think it also makes it more likely, because here you're saying that you're compelled to do it. So you always have the defense that, well, I didn't really want to say that the discovery statements that were lies, were violations, but I had to, because this is what is required.
And I have just another question, because I know there's the comment that Hunter made and that Dan followed up on about weaponization of the rule. I know that's kind of a public comment that's been received by others. And my understanding is that option C is based in part on the Illinois Rule of Professional Conduct. Are we aware of, I don't know if anyone from the subcommittee or if Erica has any information on, have there been issues in Illinois relating to the enforcement of option C, or a lot, is there any kind of data that we have about how many reports have been received under this C2 option?
No specific data as to, as far as, I think we can talk about discipline versus data. So option C2, again, because it's a violation of 8.4C, is something that has to be reported in every jurisdiction, including Illinois. So with the caveat that it has the substantial question limitation in all of those jurisdictions. So, an argument could be made that every other jurisdiction is dealing with these concerns about weaponization and so on. So, California is unique in that there are a lot more licensees in California, but otherwise, I don't know that California lawyers are going to weaponize this any more than any other jurisdiction. Perhaps, I'm not able to say that. But as far as discipline on this rule, there are limited instances where an attorney has been found to violate 8.3. I think Joel gave one earlier. I'm aware of one, I believe it was Louisiana, where the lawyer was aware of another lawyer, a prosecutor who was aware of exculpatory evidence against a criminal defendant and didn't disclose it. The prosecutor didn't disclose it, and their colleague also didn't disclose it, ultimately until the individual was about to be put to death. And that led to a violation of 8.4 by that attorney. Oftentimes 8.4 violations are co-conspirators. So it can be, there can be an 8.3 violation where two lawyers are acting in concert to have violated the same set of rules. And they also haven't reported on each other for violating those rules. So that's another instance in where it has been raised. But I don't have any data that I could give that this is leading to, a high number of complaints in other jurisdictions, just because I'm not sure that that's been, I mean, maybe it does exist and that's something someone could look into, but I wouldn't have it for this meeting.
And regarding the numbers, is approximately, in terms of just comparison with Illinois and California, I think there's about 100,000 more lawyers in California than.
Yeah, and in response to the question Raquel raised earlier, I just wanted to briefly weigh in terms of why we're opposed to option C, although Brandon did support it. And I actually would support it as an alternative option to option A with some tweaks, because I do think the substantial question modifier is important to be consistent, and also just to emphasize the seriousness of the misconduct that would require reporting. So I would prefer that language to modify both 1 and 2, then that reflects adversely, that's in C1. If we were to consider option C as an alternative, but I just wanted to weigh in briefly in response to Raquel's question, because I do think both options A and B are pretty narrow. And I understand the reasoning behind having them be narrow, but at the same time, I'm just trying to be somewhat, I guess, realistic in response to some of the public feedback, and considering the parallel Senate bill that's being proposed. So I'm looking to see if there's any other hands raised. Did anyone else want to weigh in on option C in response to Raquel's comment? And Ken?
Do we have the text of this Senate bill? I haven't seen that. I'm not.
So I don't know if Angela could put it up on her screen, but the one thing I wanted to just point out is that the Senate bill proposal, it appears to me to be identical to the ABA model rule, subsections A and C. It just doesn't require the reporting of judicial misconduct. So I can, it would require a licensee of the state bar who knows that another licensee is engaged in professional misconduct that raises substantial questions of that licensee's honesty, trustworthiness, or fitness as an attorney in other respects shall inform the state bar. And then it has the same exception in B, that it doesn't apply to information that is otherwise protected by the attorney-client privilege. It doesn't have the duty of confidentiality reference. It says, or information gained by a licensee while participating in the attorney diversion and assistance program. But it pretty much tracks the ABA model rule, Ken.
Yeah, I'd just like to make one further comment too, to kind of expand upon what Hunter was saying on the option C2 issue. I mean, I've had situations, I have one going on now, where in settlement negotiations, the other side is making a false statement, a false allegation. I know it's false. I can prove it's false. I've pointed out that it's false, and yet it's still being made. Do I now have a duty to report these false statements that have, if they're not intentional, they're certainly reckless because they're objectively false, to the state bar? Once again, I think what Hunter raised, that happens not infrequently, even in civil practice.
So much of litigation is about what's true, right? And the whole concept is that we're going to involve, up to 12 other people in the process of determining who's lying. So I think it's just not it. I would say that fraud and misappropriation of funds or property, I don't see how those two could be problematic in litigation. Because fraud has a pretty clear definition. And then misappropriation of funds or property, I get it. Those are the two things that I don't have a problem with in sub 2.
Yeah, Sarah, I just raised my hand one last time because I don't know what your plan is for pulling this all together or taking a vote or taking a lunch break or anything, but it just occurs to me that we have not addressed the public comment we received this morning about the reproductive rights issue. And I just don't want us to breeze through that without giving it some consideration.
Yeah, I agree with you, Joel, and my plan was to kind of turn shortly to a vote of these 3 options. And then after lunch, discuss the comments to the rule, which would include consideration of the recommendations made by some of the public comments, to include a comment that makes clear that it does not apply to attorneys who may be assisting in the abortion context. So I will, I think we should get to that, but I'm going to table it for after the lunch break because I do think I want to decide on these 3 options as an initial step so we can make some progress. And I did like, Hunter, your idea, but perhaps considering modifying C2 to be fraud or misappropriation of funds or property, to provide a clearer standard if we were to consider that. So I think at this stage, we were going to break for lunch at noon, but I'm considering whether we should take while we're still active in this discussion, take a vote on the 3 options. And I would propose perhaps, and then a second vote, I would like to know if, I guess we could see where the voting turns out first, but a second issue I would like to know is whether we should take a vote on the options and then whether or not to offer the Board of Trustees an alternative option or not. I think that I would like to take a vote on that too. But first, I would like to start off with options A, B, or C. I know there have been some recommendations though for some tweaks to, I think it was option B. Eleanor pointed out one potential edit. I may be overlooking some other edits that people suggested. So maybe I'll just before I do that, before we take this vote, does anyone have a proposal to vote on one of these options with modified language?
I was thinking of modifying B to say, or a misdemeanor when the misdemeanor is committed in. I think that would clarify that it's only misdemeanor conduct that applies to the practice of law. I don't think it's really necessary. I think it's clear, but at the same time, there's obviously been some misunderstanding. So that would be more wordy, but I think it'd be also more clear.
I'd accept that as a friendly amendment.
Yeah, maybe we could take a straw poll on that. And that way we can include it as part of when we're voting on option B, as part of the edits. Angela, could we take a straw poll quickly on that? Adding Hunter's recommended language.
You want to put it on the screen just so everyone can see it?
Yeah, that would be
Yeah, Hunter, can you repeat what you suggested, please?
So after the comma, it would say, or a misdemeanor when the misdemeanor is.
Okay.
And actually, before we, trying to think of the best way to do this.
I have a suggestion if you'd like it, Sarah.
That would be helpful. Thanks, Erica.
All right. So if you're wanting to take a straw poll on these, that's certainly something we could do again. If you're hoping for something more formal, my recommendation would be to have someone make a motion on one of them. So to move adoption of option A, option B, or option C, see if you get a second, and then vote on one of those, and then discuss whether from there whether or not to add an option in the alternative option for the board to consider, to see if you have those votes.
Okay.
Is this just a straw poll, not automatically committing ourselves to one of these? Because there are some tweaks. In other words, alert, for example, inform. I think we should be more specific. Is it in writing? Is there a time frame? So if we're loosely trying to move from where we are to something more concrete, fine. But if you're going to have all the language, because we're using a motion. So Sarah, I'm not sure where you, or is it literally straw, or is it now once we vote, this is it?
If it's straw, you don't need a motion.
Yeah, as a straw, we wouldn't need a motion. And that, I was just suggesting a straw poll only for this additional language that Hunter just suggested. But if we want to start first, I think it does make sense what Erica said. Would someone like to move?
Well, Sarah,
If you could just hold on one second, Joel, please. But what I was going to suggest is if someone wanted to move to recommend either option A, B, or C to propose to the board of trustees. I just wanted to complete my thought process before. And then Joel, if you had a question first.
You could add, sorry to interrupt, Sarah, you could add to Raquel's point, subject to, further refinement or something like that. If once A, B, or C is selected as the choice to move forward with, that you want to wordsmith it or change it a bit more. And then that would require, again, a vote, though, just to be clear, to further approve it.
Yeah, yes, that makes sense. And I think we should follow that process.
well, I would be more comfortable, and I think it would be more efficient if we take a straw poll, and then when we come back from lunch, concentrate our efforts on making the one that emerges the subject of our further edits and revisions and comments, rather than, that's just my suggestion. But you're in charge, Sarah.
Thanks, Joel. And I do think, unfortunately, we are, very limited in time. So to move this forward, I would like to try to kind of get a formal vote before the lunch break on all the options. So that way, when we come back from the lunch break, we can consider just tweaking that one option, which I think is the goal we both share, but it's just a different way of getting there. So would someone like to move on one of the three options, option A, B, or C? And it would be moved, just to clarify, it would be moved for a recommendation to propose to the State Bar Board of Trustees, subject to further discussion and refinement of that option after the lunch break.
I'll move exhibit B, or option B.
Does anyone second that motion?
Ooh.
I'll second it.
Who seconded it?
Bill.
Bill. Okay, so this is a vote for option B, subject to refinement. Correct. All right, I will take the vote.
Angela, I just want to clarify for the motion. So if B moves, if everyone votes in favor of B so that the motion passes, we would be moving forward with option B with modifications, just so everyone's clear.
Thanks, Erica. I'll take the vote right now. Bacon,
You're on mute.
No.
Brown,
No.
Bradley, Chivers,
No.
Krieger. I'm sorry, Brandon, you cut
Oh,
out.
I'm sorry, no.
Mark,
Yes.
Mercado,
Yes.
Munoz,
Yes.
O'Reilly, Poindexter, Star,
No.
Benola.
No.
Yay. Sorry for the enthusiasm. I have my hand up and Joel jumped to the point, so I could have saved you, Joel. Maybe. We can go for another motion, right?
Yes, I was gonna suggest, and I don't know if, Dan, are you back with us? Because I didn't hear him vote, but,
He didn't.
okay. But
He might have stepped away.
Okay, so, but we still have okay, so I'd like to move, do we still no, we still have plenty. I'm just making sure we still have enough for a quorum without his presence.
Yeah, you have 9, you have plenty.
Okay, so, would anyone like to move for one of the remaining options, B or C?
I will.
Which one, Raquel?
Well, I'm
I
moving
thought we just
option.
voted B down.
Yes.
We did, so now it's A or C.
Oh, I misspoke. Sorry about that.
Yeah, so I'm moving that we accept option C to move forward to the Board of Trustees as a recommendation, subject to tweaking the final language. Do I have a second? Not that I asked for my own second, but
Does anyone want to second Raquel's motion?
not even Brandon, huh?
Well, I'm sorry, I'm reading, so Hunter just posted, and maybe he posted it a little while ago, but Hunter posted a synthesis of C and A.
An A, right?
Chat.
But it's not an option we have at this point, right? So we have to vote all these down if we want to go to another.
Is that right? If we wanted to consider Hunter's synthesis, do we vote for A and then offer this after lunch, or what do we do?
I think you could, Angela, can you put Hunter's recommendation on the screen?
So don't we though we'd have to set aside, we have a motion on the table. So I don't think we can do what we're about to do.
You don't have a second yet, so if there's no second.
Right. But it's still on the table, so I can withdraw it, which I will be happy to do. So I withdraw the motion. Thank you.
So just to clarify, my understanding is that if we move, the next one that we'd be moving on is option A. And then we could consider as part of after the lunch break, if we decide to further consider option A, it would be subject to additional revisions. So we could consider Hunter's proposed kind of synthesis of C and A after we vote on the option A that's currently on the top of the screen.
In that case, Sarah, I'll make a motion that we consider option A.
Okay, and so that motion, does anyone want to second Hunter's motion to consider option A, subject to further revisions of option A?
Okay, I'm confused on what we're doing, so I'm not seconding it. So I'm confused. So I need clarity. I'm sorry. Let me just say that. Because we now have option A and C on the screen, but you're talking about A. So what are you, Chair, what are you suggesting?
My understanding is that Hunter just moved for adoption of option A, that it's not showing on the screen now. But Angela, if you could just scroll up. So moving for Hunter is moving to recommend option A to the State Bar Board of Trustees for further consideration, subject to further modifications to option A that we'll discuss after the lunch break.
Thank you.
So we can vote yes on this, but still vote no later if we don't like the modifications or aren't satisfied. Is that right? Okay, then I will second, but I appreciate the clarification because I was confused as well.
Okay, I'll take the vote. Bacon? Brown?
Bacon's on mute. You're on mute, Kevin. Kenneth.
I'm sorry, I'm still confused as well, but I guess I'll vote yes on A, subject to the revisions after lunch.
Thank you. Brown,
No.
Bradley, Shivers,
Yes.
Krieger,
Yes.
Mark, Joel,
Joel, you're on mute.
I said I will abstain for now.
abstain. Okay. Mercado,
Yes.
Munoz,
No.
O'Reilly. Deanna, are you there? Poindexter, Star,
Yes.
Benola.
Yes.
6 yeses and 2 nos. So the motion carries.
Thank you. So I'm going to suggest that we take a lunch break. It's now 12:12. So, or just change, but maybe returning at, so it's an even, maybe returning at 1:15 for further discussion of option A, potential modifications to option A. And then we'd also, after the lunch break, we should be prepared to discuss comments to the proposed rule. So I suggest we just take a break for lunch for about an hour and everyone return at 1:15.
Okay, can I request that since we know it's gonna be the combination of what Hunter has offered, that in the lunch hour, that when we come back, we have the actual option as it would be stated completely. So there were some red lines and some other things in what we voted on before, but actually come and put it so we can make sure we know how it's gonna look and what it says specifically.
Yes, but we'll have a clean version of proposed, what is essentially A with the C modifications.
Although, just to clarify, Erica, I think that would be, at least for me, that would be confusing. I think that it'd be helpful to, when you say clean version, to show the options. Maybe you meant this already, but I might not have understood.
I did. I was not clear. So we can put option A into clean, so accepting the red line changes that are currently in it, and we will put the C revisions that Hunter suggested into red line itself.
Yeah, that would be helpful. Thank you. I understand.
Or really, is it not a new option? And why don't we just make it a option D? Because it really is it's not A, it's not B, it's not C, it's its own thing.
Well, I think we're trying to work off of A and then debate what changes to A we would make. But I take your point. I think we could go at it either way, but I think we're trying to get the same spot either way.
Yes. That's how I view it. And we've already voted to approve option A subject to modifications. So I think we should proceed by just presenting it, as Erica suggested, a clean version of option A, showing the edits that Hunter recommended, so we can consider them further after the lunch break. And I think timing just worked out perfect because it's exactly 12:15, so we can resume at 1:15.
Thank you.
Thanks, everyone.
Thank you very much.
All right, hope everyone had a good lunch break. I wanted to resume, if Angela, if you could share on the screen a version of option. I'm not sure if we were able to put together, it looks like we were. So what's showing on the screen now, just for everyone who might have joined after the lunch break. Before the lunch break, we discussed modifying option A, which COPRAC voted to consider further, to include some additional language and modifications that Hunter proposed. So I want to open the discussion up to these revisions. And Hunter, maybe you could explain the reasoning for these revisions as an initial part.
Well, Raquel was pointing out some of the things that we saw in C as being, things with which we should concern ourselves. When I looked at C, the first things that stuck out to me were the things that were problematic, right? The things that are going to be weaponized, the things that are going to make litigation just a nightmare. But there were a couple things in C subsection 2, like fraud and misappropriation of funds, that I don't really see being a problem in litigation. It's one thing to say, well, there was a misrepresentation, but I think that when we're talking about fraud, we're not likely to get those two things mixed up in litigation. And to the extent that it would ever rise to that level, you'd probably see a judge saying, look, that's a fraud. And the judge would probably be handling it at that point. But in terms of misappropriation of funds or property, that's another one where that may not be criminal, but it is the type of thing that I think that you would want to report or mandate reporting. But also, it is not something that's really going to be weaponized in the context of litigation, at least not that I can see. That being said, guys, I don't deal with money, generally speaking, in litigation, so I could be wrong about that, but I don't see that being a problem in litigation. So it's really, I tried to take from subdivision 2 that which we want to concern ourselves with, but which will not be a problem along the lines that we've discussed it. So this way, this amended rule or synthesized rule would technically be broader than A, but would still have the type of professional discretion that Cassidy was talking about. And it would be narrow enough that if non-criminal conduct, I think we could generally be comfortable with that kind of conduct being covered by the rule. So again, I think it strikes the proper balance between A and C without unduly opening us up to the problems in litigation. But it was a little bit off the cuff because I'm noticing there that C was not a terrible recommendation in every respect. It was just problematic for a few different reasons. And as long as we set those aside, we still have a couple that we can incorporate. And I think in terms of having a rule that best serves the bar and the public and takes into considerations realities of litigation, I think that that's a good balance.
Thanks, Hunter. Does anyone else want to provide feedback on the proposed edits to option A? Not hearing any. I'll just note that I agree with you, Hunter, about these revisions kind of striking a good balance between A and C. And also, I do believe these edits are responses to a lot of the public comments that I reviewed, particularly those that were concerned that what went out for public comment, that the proposal was too narrow by just being limited to a criminal act. So I do think these changes do appropriately balance some of the feedback that we've received. So since Brandon, did you want to?
Yes, please. I'm very much in favor of what I believe we are aiming for with the revisions to option A. As a drafting matter, I'm afraid that now we are saying you only have to report fraud or misappropriation of funds if it raises a question as to the lawyer's honesty. I think what we want is for that final clause about raising a substantial question to modify the criminal act, and then separately, if you know about fraud or misappropriation of funds, you just have to report it, right? That's what was my thinking. Because it always would be a substantial question of your fitness if you're misappropriating funds.
Also, when we're talking about misappropriation of funds or property, do we mean client funds or property? Or just any funds or property?
Oh, that's a great point. I was assuming client, but it doesn't say it.
I think it would have to be any, because, you have a fiduciary duty if to hold other other people, other parties' funds if you're required to do so under Rule 1.15. So, if you steal those funds or you steal client funds, there should be no difference between the two.
Well, that, excuse me, that I would agree with, and maybe we could make that more clear. I guess my question was misappropriating of funds or property. I mean, how do you distinguish that from petty theft of property? You steal something from a grocery store.
Well, should we say reference from a trust funds or property or reference 1.15 or something like that?
Yes, I would think so. I don't have the specific language in front of me on my brain right now, but
You could put in violation, so engaged in fraud or misappropriation of funds or property in violation of Rule 1.15. That might be
That would make it more specific. As to the question as to whether it should still be subject to raises a question as to the lawyer's honesty, trustworthiness, or fitness as a lawyer. If all situations involving fraud or misappropriation of funds or property would in fact implicate that concern, then having it modified by that does not detract from the rule. But if there is ever outside of our conception of when that might happen, where a fraud or misappropriation of funds does not raise that concern, then this would be overly broad. And we're getting a little nuanced there, but that's just my feeling on that.
if we want to make that distinction, but still keep that other language, we could put the or engaged in fraud or misappropriation of funds or property at the end of this paragraph after where it currently says 8.4b. So the substantial question of honesty, blah, 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 would relate to the criminal acts. And then or engage in fraud, misappropriation. Just a suggestion.
I think substantial questions should apply to all of it, to all the conduct. I think there are situations where, misappropriation is a serious offense, but there are situations where lawyers have a nominal amount of funds in their trust account, and there's maybe a lack of clarity if it's attorney's fees or client funds, and it's maybe somewhat an honest mistake, or can be considered an honest mistake. I think substantial questions should apply to all conduct that's reportable.
I have a question with this formulation. Are we saying that a criminal act, a fraud, a misappropriation of funds or property are all the kinds of things that would have to be reported without further qualifying that it requires, well, by their very definition, they bring into question the lawyer's honesty, trustworthiness, or fitness to practice. And if that's really what we're saying is, don't we want to say something like criminal act, engaged in fraud or misappropriation of property, other conduct that raises?
Brandon, it looks like you have your hand raised. Do you
Oh,
wanna-
I'm sorry, that's a mistake.
Oh, that's a
because I
mistake.
Forgot
Okay.
to turn it off. That's
But just briefly then, I did not understand that to be the kind of what we were considering here, to add or other conduct would make it very broad. And somewhat vague. I understood we were purposefully, the initial drafting of this is to add the raise a substantial question to make it clear that the criminal act or fraud or misappropriation has to be serious enough to raise a substantial question as that lawyer's honesty, trustworthiness, or fitness. That's how I read this and understood the intent of these revisions. I also I agree with Cassidy's comment about having the substantial question language modify all three. That's also consistent with other versions of the 8.4 where they use this term substantial question to modify a violation of the rules of professional conduct. And here, some of these, the misappropriation of funds or property, we're referencing the violation or considering referencing in violation of Rule 1.15. And that would be modified in the other, some of the other states in the ABA model rule by which raises a substantial question as to that lawyer's honesty. So I'm in favor of having the substantial question modify everything. And I've lost my train of thought, but I also support kind of misappropriation of funds or property, as Erica suggested, adding the language in violation of Rule 1.15 after property. And that's just for consideration, but I think if we do that, we don't need a comma. Yeah. Is anyone opposed to adding the in violation of Rule 1.15 language? It sounded like.
I think it's a good idea.
Well, then you'd have to move your comma to after 1.15 if you want to get when that conduct modifies everything. Wouldn't you?
I think that makes sense,
Or
Joel.
not?
And Raquel, did you have some feedback you wanted to provide?
I did. 3 things. The first one is someone offered that we should consider putting not only a lawyer, but the law firm. And I thought that was effective. So that's one. I thought that the idea of shall inform, that being specific, I'm thinking it's something that's in writing versus somebody making a call or something else. There was an issue of timing that came up in a lot of the comments. I think by saying when the lawyer knows means at that time, meaning don't wait years from now. I know there's some comments that say some reasons why you might wait, but overall, so I just want to clarify that that is what the intention of when the lawyer knows, meaning at the exact time of that. And then the final comment is around dishonesty, deceit, reckless or intentional. And I did hear Hunter and maybe others also talked about the idea of it being used to weaponize and or being used, you didn't use this word, Hunter, but I'm just going to say legal strategy. I think you use more like aggressive, we're aggressive. And I would just say as a regulating body, my sense would be we don't want attorneys engaging in dishonest, deceitful, or reckless behavior. So while someone may try to weaponize it, I don't think that's the reason not to put it in. I think it's to put a stake in the ground to say that type of behavior is out of bounds, and those who are doing it should not be doing it. And we're not condoning. We're being outright and saying we're not condoning it, because I think that the implications of that are what the public comment said from non-attorneys or victims, as they may call themselves, is that they are losing a lot of, yes, or can I just finish and then you can come in? Thank you. And so then they are losing trust in the profession. And so I think that that's important, more important than the fear of weaponization. And I'm over.
I had a question, Raquel, about are you suggesting a comment that basically clarifies that the rule is meant to apply to the profession of lawyering and should not be read as a rule that is supposed to govern litigation tactics.
So you probably being a more technical than my commentary, not being an attorney, but I was responding to you saying loosely, right? So you didn't say what I'm saying, but my interpretation is, hey, we kind of say different things, and you use the idea that, your opposing counsel said he didn't disclose this. That's not the word you use. I forgot what the legal term is, but he didn't give me this discovery in the proper time. And you said, hey, no, here it is right here on this dump truck. And that people just do that because that's part of their legal strategy. And so that was the commentary in which I heard you saying that can open a whole Pandora's box if we talk about dishonesty and deceit, because we know that that happens in the profession. And so that was what I was reacting to and saying, okay, that's great. I mean, that's not great. I don't think it should happen. And therefore, I think we should start putting a stake in the ground and saying that's out of bounds, guys. That's not, as a state bar who's supposed to be operating as a regulatory body. I don't think that, thus I think why the state, the council put in number 2 the way that they did, because that is out of bounds. Even if people are doing it, they shouldn't be doing it.
So 8.3 would be included in 8.3 for its deterrent effect on that type of behavior, essentially, because other lawyers would be on notice that if they do this type of behavior, another lawyer has to report them for it. Is that?
Can I get, because that's the distinction I was getting at. We're not condoning this. That's already improper conduct under Rule 8.4C. It's misconduct for a lawyer to be dishonest and intentionally reckless and misrepresentation. The issue that I think Hunter raised, and that I was kind of talking about earlier, is do we want to extend that now to where opposing counsel, particularly in a litigation context, is now put in the position of having to report what arguably could be misrepresentations by opposing counsel? That's not condoning their conduct. Their conduct's already bad under the rules. It's a violation for them to do that. But do we want to say now every lawyer that hears something that's intentionally false, it's false, you can prove it's false, has a duty to report that to the state bar? I mean, I agree with Hunter. I mean, that's a real Pandora's box if we go that route.
Yes, and I think it's also provides a less clear reporting duty. And I mean, Hunter went into this, but there are a lot of different examples in the discovery context, for instance, where it might not be clear whether, I guess the rule is intentional or reckless misrepresentation, but the opposing side might say something that's false, and it could just be an oversight potentially. So I do think, the language we have here is clearer cut. If we were to add a language that is in C to A, we'd essentially be considering option C, which I don't think was part of what we voted on before the lunch break. But I'll pause to see if, I guess, just focusing on Raquel's, she raised 3 issues. I think since we're in the middle of discussing now, I think she was proposing that option A should incorporate dishonesty or misrepresentation as is in subsection C. So are others in favor of adding that language to option A?
Boy, that doesn't sound like that bodes well on the profession of attorneys. I'll just say that as a non-attorney. Like, we know they lie, but that's okay. We won't report them. Because maybe sometimes we lie too. And I can say that as a non-attorney, that's how I hear it. Like that is clearly really how I hear it. There's a rule, but people tend to not report.
Let
So
me,
then the rule has no effect
so if I
on
may
the
comment,
attorneys.
just to offer my perspective is that I have tons of discovery disputes with opposing counsel where I believe they lie in the course of my career. I have several considerations. One is that I have written a couple dozen state bar complaints in my career for grave offenses, and they've never yielded any results. So I have deep concerns about what the state bar does with the gravest of complaints. I can't imagine they will be any better at investigating and preventing and the real grave harms if they're inundated with mandatory reporting every time someone says, you know, I believed Mr. Krieger gave me an extension on this or that, you know, these sorts of, and it does reflect very poorly on the profession, but to me, it's not saying that I lie too or anything like that. It's just that, you know, I see judges where I believe the other side has been manifestly dishonest and I've been nothing but pure and wonderful. Send us to the jury room and just say, you two figure it out. I don't want to deal with this crap. And I don't see a lot of good coming from it. It's a sad commentary, but in no way am I suggesting that I want to be able to get away with, you know, dishonesty. I would spend a lot of my time reporting a lot of people for things that aren't, but I do file reports for the really grave stuff. Anyhow, that's my comment on it, which is just a subtle difference from the response, how it struck you.
And I think that part of the reason we got so much interest in the public comments is not that attorneys are in any way pro what we're trying to address here, so much as what we're doing is we're making it the burden of presumably ethical attorneys, right? We're putting this on their shoulders and then saying, if you fail to do this, we're going to punish you. So anytime we're opening up new punishments to the attorneys who are not violating the rules, those attorneys are going to look at it and say, well, hold on a second. So because the state bar, and this is kind of the general tenor of the comments, because the state bar fails to correctly respond to the complaints, now I'm going to face misconduct if I don't take it upon myself to report these attorneys. And I feel that the emotional response that we're getting from the comments is you're punishing me for being a good guy when the guys who are the bad guys are the real problem here. And I think that's the emotional response that we're getting. And one of the things that we're trying to avoid, because there is a certain point at which we have to make the rules not unfair towards the ethical attorneys. But as you've quite correctly pointed out, we're also trying to weed out the unethical attorneys. And a grassroots method of doing that is really what this rule is about fostering.
If I might also add, it is my perception, or maybe just my belief, and maybe others don't share this view, that a lot of the cynicism with which many are treating this rule, sometimes myself included, is because of the belief that it distracts from a more fundamental problem with the administration of disciplinary investigations, and how, you know, the Girardi scandal is the prime example, where there were hundreds of complaints, and we don't need necessarily more complaints. We need a system that is robust in addressing the very grave violations that are put in front of it. So, you know, I share a lot of those thoughts. I don't have a problem with 8.3, and in a perfect world where we had a perfectly functioning disciplinary system with enough capacity, I think it'd be fine to require reporting lawyers for every lie and just stamp that out. I'm just very concerned that in the reality in which we're functioning, it would make the really important stuff worse. That's one of my concerns.
And Erica, did you want to provide some feedback?
Yeah, I just want to respond to Brandon's sentiment. And I think that's a sentiment of, several of the committee members and several of the public commenters, certainly, that, there were numerous complaints made against Girardi, and there are, several of the public commenters that were non-attorneys as well. Many of the attorney commenters commented that, and Brandon, you just said, I filed complaints indicating grave violations, and they're not, it doesn't result in discipline of an attorney. So that's certainly a valid perspective. I just want to add, OCTC, who will be dealing with the burden of all of these complaints, is proposing to expand it to what Raquel is suggesting. So that the the Office of the State Bar that will be dealing with this, weaponization leading to even more complaints is the one advocating for it to be broader. So I just want to make sure that that perspective is also considered, and then recognizing that you can have your feelings on what they do with those complaints once received.
Thanks, Erica. Hunter, do you still have your hand raised, or did you have some other feedback?
I do have one comment, and we are getting far afield from what does A look like and does it address what it needs to address, but I don't see another way to really kind of put my thoughts out there on doing this in the first place. Obviously, we've been given a directive to look at this. Just from a concept of leadership, and the State Bar is the leader, right? It's the organization that leads. There is something I've been studying lately is leadership and how to be a good leader versus how to be a toxic leader that drives people away. And one of the things that I've found is if leadership is not doing what they're supposed to be doing and they get called on it, and their response is to go to their people and say, you guys need to do better, that is going to be perceived, even if true, as toxic leadership. And so I think we should be looking at this aside from what it's coming from. But I think it's going to be perceived as the bar blaming its members for what the bar didn't get done. And this is essentially from the comments and from just kind of the grassroots hearing what attorneys are saying about this. I think that that's going to be how it is perceived, which I think is one of the reasons why I think it's so important that we draft a correct rule, and one that when lawyers read it, they'll read as, this is not undue burden on me, and it is not blaming me for the problems. So one that comes across as reasonable and manageable. That didn't really fit in any of our discussions, so I did want to put it out there.
Thanks. And just some other feedback that I think, Hunter, you might have raised this previously too, but it seems like a lot of there was some concern about adding dishonesty or some of the other language into option A. And a lot of the examples given were discovery disputes and conduct in relation to that. And there's something that prohibits the reporting of that, which the proposed revisions clarify that under subsection, I guess now B. And also there are other avenues like motions to compel and motions for sanctions where there's really a misinterpretation made in connection with discovery responses. And I know many, just by experience, when I've had when there's been opposing counsel who I feel is making a false statement in a pleading or discovery response, and if you call them out for that and they still refuse to retract it, you have other avenues through the litigation process to try to address that. I know, there could be other examples outside the litigation context where I understand the concern, but it's, Rule 8.3, if I have the rule, or is it 8.4? I'm sorry, I'm getting my rules messed up now, does already prohibit this conduct. It's just the reporting of it, as Ken pointed out, that we're debating right now, mandatory reporting of it. So I wanted to, does anyone else want to weigh in on this topic? So I wanted to move on to another issue that Raquel raised for further consideration.
Not that, well, is the further topic going to be including law firms? Is that where you're going?
Yeah, I was gonna go on to that
Yes.
next. I want to make sure we address each issue.
Is
So
that
it sounds
comment
like
on-
there's, I don't know if there's any other discussion on incorporating basically, it's kind of reconsidering option C essentially by incorporating the language from option C into option A. But I wanted to now talk briefly about the other suggestion that was, I think Eleanor suggested it earlier. And Raquel supports it, it sounds, by adding law firm. And I guess it'd say, would the suggestion be, Eleanor, if you want, or Raquel, to say credible evidence on another lawyer or law firm? Is that what you were suggesting?
I was suggesting we consider it. I hadn't really thought it through completely, but it seemed like it might be worth some discussion. And yes, that would be where it would fall.
Okay,
Can I comment on that one? Because
that would be great. Thanks, Ken.
I think we can short circuit that, because this is a duty to report to the state bar. Law firms are not subject to discipline with the state bar, so why would we impose a duty to report something that the state bar can't take any action on?
That's fair. You know, I think it's a really fine point on it immediately. So thank you. In that light, I think that it doesn't make sense. Does anyone disagree?
Well, I thought professional corporations can be subject to discipline. Is that correct? Am I missing?
Is that under the State Bar Act?
No, okay.
I don't think so.
Yeah, that's something we run into with meant for fee arbitration, where you can only issue an award against an individual, not against the firm for discipline purposes.
Sarah, if it's okay for me to just add, so that's certainly correct. The state bar cannot discipline a law firm. That being said, you know, you could report on a law firm, and then with further, you know, interactions between OCTC and the complaining witness, perhaps they could investigate an allegation that's made against a law firm as a whole, and then determine which employee of that law firm or individual within that law firm, depending on the relationship, obviously, has committed misconduct, you know, one or more. That's just another consideration on the opposite side that you
Yeah,
want.
I think that's right. But as a practical matter, I've seen this happen where they just randomly pick a lawyer to send the letter to. And the lawyer, and you know, and the lawyer's like, this has nothing to do with me. And so I would hate to have that to be part of all the confusion that's inevitably going to follow from this new rule.
Yeah. So, and I believe all the other rules are directed to lawyers' conduct. So for consistency purposes, that's another reason kind of, to me, weighing in favor of not modifying it to include or law firm. But I did want to pause and see, does anyone feel that we should add or law firm?
The argument that might be made is that firm is defined under 1.0.1 under terminology, and the lack of the use of firm in all of these disciplinary rules, but instead the use of the word lawyer would seem to indicate that if they wanted it all to apply to firms, they would have said so.
You know, this is making me wonder under option A, how it would capture or not capture an instance where a lawyer is failing to supervise an employee who's stealing all the money or something. Is that a mandatory reporting? It should be, right? But I don't know if it would be captured here.
Yeah, and I feel like that was part of Eleanor's initial comment as well, her concern.
Yeah, exactly. And now when I look at the precise language, I think it might slide through when we don't want it to. Because, you know, you have a duty to competently supervise, but we but we aren't triggering a reporting duty off a violation there.
I think it's in there already though, isn't it? I mean, the duty to sue, Joel's right, law firm is a defined term. And it pops up in rules, I think 5.1 to 5.3, which talk about managerial attorneys or supervisory attorneys in a law firm. And that they have the duty to supervise and do whatever actions are necessary. So it's already, you know, the lawyer, whether the lawyer is the managerial in the firm or what, is already in there. Adding, because again, I don't think adding law firm to this adds anything and creates potential issues.
And wouldn't adding law firm as the, to another lawyer or law firm, how can another lawyer know an entity has committed a criminal act? I mean, it just kind of gets away from that knowledge element, because you should know what the person did as opposed to just generally, what's going on in the law firm.
Yeah, I tend to agree with you, Cassidy, and what we're referencing here, criminal act, fraud, and misappropriation of funds or property, with reference to other rules like 1.15 and also 8.4, which do refer to the lawyer's conduct in those other rules. So
yeah, I think it unintentionally adding the law firm in there would unintentionally broaden the scope beyond what we want.
I think I'd like to move forward, but I want to make sure that maybe we could just take a quick straw poll, because I'm not hearing like a consensus on this. So maybe we could take a straw poll on who is in favor of adding or law firm to option A, which would follow another lawyer. So Angela, could you take a quick straw poll on that?
Sure. So this is adding law firm to the language. Yes is add it, no is no. Bacon?
No.
Brown?
No.
Bradley? Shivers?
No.
Krieger?
No.
Mark?
No.
Mercado?
No.
Munoz?
No.
O'Reilly?
No.
Poindexter? Star?
No.
Vanola?
No.
Okay.
So I guess I was wrong. We were just playing devil's advocate. So I guess let's move on to the final issue that Raquel raised, which I wanted to briefly comment on, and then I'll open it up, which I think it's whether to use a modifier promptly before inform. And I did want to point out that we do address the timing issue in comment 3. And I think this is something that we thoroughly discussed at our last COPRAC meeting, about the timing issue, and we elected to go with comment 3. But I just wanted to, it might be helpful too if someone from the working group could weigh in on this issue in response to Raquel's comment about the timing issue.
Well, I'm not sure we discussed it clearly in the working group, or at least my recollection isn't great, but I seem to recall that the OCTC wanted the word promptly in there for reporting. Erica, does that sound right?
Sorry, I had to find my cursor. Yes, that is correct. So one of their, what is option, or what was option C, but the working group did discuss it briefly and did not agree with, was adding the word promptly into the timing requirement, because we didn't spend a lot of time on it, I don't think, at the working group discussion, but I think in part because it was already covered by the comment as opposed to putting it in the body of the rule itself.
Okay, okay. Thank you, because I had forgotten that.
Yeah, I have a question too. I don't know the answer off the top of my head, but lawyers have duties to self-report certain things. I don't remember what that said. Does it say promptly? Does it say within X number of days? Because I don't think we want to put a burden on a lawyer who now has to report somebody else's misconduct that is greater than the reporting duty on the attorney who committed the misconduct.
I think we'd have to look at Business Professions Code. Is it 60680 for the self-reporting? Is that right? I don't know the answer off the top of my head.
30 days.
30 days.
Yeah, but that's 30 days from like a conviction, right?
Well, knowledge of any of the
Oh.
following.
Oh, that's okay. Never mind.
Cassie, to your point, there are things with clear dates associated with all of those things for the most part. So it's like an indictment, the filing of 3 or more lawsuits, entry of a judgment, conviction. They are things that have a clear traceable date.
Right.
And then the lawyer has to do it within 30 days of that event.
Correct.
Right.
So.
I mean, I think I just go back to what we talked about before is that, if it's prejudicial to an ongoing matter, if it's going to impact the client representation in any way, then, that has to be taken into account. And I think before we landed on not having the timing element in the rule. And I think I still stand by that.
Thanks, Cassidy. And I do recall that discussion, although I'm not a member of the working group, but I do recall that discussion from our full committee meeting. And one other issue that I wanted to point out, just based on the public comments that I reviewed, many of them were concerned that the duty to report could potentially conflict with the client's instructions or the duties to the client. Or other law. So there are a lot of factors that might come into play where it might not be possible to do it promptly. We addressed to some extent in the comment. But I think based on the public comments we've received too, it seemed like they were concerned about the reporting duty conflicting with your duty to your client or your client's instructions.
And I also think that putting a hard and fast date is going to get the same kind of pushback that we got about the 14 days to report, to a client of receipt of funds on the other rules. So this rule has got enough controversy. I'm not sure I'd want to add that one into it. Okay. Well, I just, I don't know. I hesitate to do too many straw polls. So I think, is anyone feel like we should add the word promptly to option A?
I know. Let me just speak in favor of it. And if not persuasive, we won't have it in. I think it's more using the word is more in the spirit of saying, this is important. You have an obligation to do it sooner than later. You have a comment in that I think is being proposed that gives people enough definition and discretion to decide in their individual context how soon is prompt. But I think, to me, I just think it's signaling, report when as soon as you know it, don't drag it on. And I don't think it has to be some some onerous way to report it. So I don't think it's going to take away from other things people are doing. So that's the way I read prompt, or putting, prompt to me is the loosest time frame you can put. If you start putting times and days, then I think you probably are, we would be putting something that, one, we can't regulate because you don't know, and two, is too high of a standard because the situations are too varied to just choose a date. So that would be my reason for saying, I think it's a signal on the importance, notwithstanding what Brandon and others have said, is that this role is really the tail wagging the dog, meaning the problem is the dog, not the tail. The problem is what happens when people do, no matter how soon or how long. That really seems to not be the issue, but since we're on the tail, then I'd say, well, let's try to make it as effective as we can. In the spirit of what we're trying to do.
Raquel, you've convinced me, because otherwise we're forced to answer the question of how much delay to report becomes a failure. At what point in time does that occur? And I'd rather answer the question of what is promptly than the other one. So you've convinced me.
Eleanor, did you want to weigh in?
Yeah, I think in the spirit of putting a time frame on it, but keeping it fairly loose, I would advocate for without undue delay, which I think builds a little more discretion into the reporting time frame than promptly, because it calls for an evaluation of the circumstances, but also makes clear that it should be, prompt unless there's a reason to delay, which might be considering all the various factors we've listed in the comments.
The rule on when you have to get client consent to a fee split agreement says as soon as reasonably practical. I don't know if that gets us any closer or further away.
Brandon, you had your hand raised.
So I just want to join in Raquel's and Joel's position. I think promptly is great, or if without unreasonable delay, or I think all of those we need that concept in the rule. I think it's very important. And I actually need to apologize. I need to sign off. And I'm sad not to see this jalopy make it across the finish line. I wish you all good luck. I'll see you next time. Thanks.
Thanks. So I think we know Brandon's position, and it seems like there are a few in favor of adding either promptly or without undue delay to modify the timing aspect of option A, the reporting requirement. So I'm thinking maybe we take a straw poll on this, but I don't want to, maybe just by like oh no, that might be too difficult. Let's start with without undue delay. Who's in favor, or actually instead of that, who's in favor of adding maybe any timing limitation, whether it be promptly or without undue delay, and then we can decide on the exact language.
I'm on the fence.
I'm kind of, but I see 1, 2, 3, 4, 5, 6, 7. I think we're all, it seems like most of us, the only hand I didn't see raised is Ken's. If I'm wrong, speak up if you oppose it. Okay. And I'm kind of on the fence as well. So it seems like maybe for consideration for the final vote. Okay, so by a show of hands, who's in favor of without undue delay? Okay, so Bill didn't raise his hand. Joel and Ken, right? The three of you did not.
No, I actually wanted to just pause for a second, because it seems to me with the comment giving you all these reasons why you don't have to do it, those comments modify promptly if we put it in there, wouldn't they?
Correct. I agree.
So then I think promptly is the better way to go. So that's my vote.
They also modify the concept of undue delay, because if you refer to undue delay, then it implies that there is due delay, right? There's appropriate delays at times.
Which could extend beyond the comments, things we're not considering potentially. I think it gives a little bit more wiggle room to it, which I like.
Or we could keep the comment, but just take promptly out.
And we could also consider tweaking the comments to say without undue delay to be consistent, but I think it's a little, I'd like to kind of move on because we're really running short on time. So I think what I'm just going to do, just because it's really hard to follow the hand raising, is I'm going to take a straw poll on without undue delay, adding that a lawyer shall inform the state bar without undue delay. Is that where it would fall?
Should we just a quick question, should we just do an A, B, or C, like, without undue delay, promptly or nothing?
That sounds, yeah.
Okay.
So Angela, could you take that poll?
Sure. So it's without undue delay, promptly, or nothing. Okay.
It's can for just in generally speaking, not from a technical standpoint, what is the difference between promptly and undue delay in your mind, Eleanor?
In my mind, without undue delay, it calls for consideration of the circumstances, like a fact by fact kind of consideration.
Okay, thank you.
Can I make one more point? I think, and this is what Raquel was talking about before, sort of, the use of the word when, a lawyer shall inform the state bar when the lawyer knows of credible evidence. I think that might even imply promptly.
Cassie, I don't mean to interrupt you, but I thought this exact same thought last time when we were talking about it. The problem is knowledge is a continual thing. So you could wait 5 years and it's still when you know it. So I don't think it actually does deal with that issue.
Okay. But let's just assume that's true. I think without undue delay actually makes it narrower. It actually relaxes the standard of the timeliness standard. If some investigator or trial counsel is gonna say, well, what, it means prompt, we would take care of that by inserting undue delay. So that's why I would be in favor of that.
Okay.
Can I make just one further point?
Sure.
Sorry.
It already says when in A, shall inform when. So that's to some extent a temporal point right there. And that's the language that trial counsel used in option C. So I think
that echoes Cassie's
promptly
point.
or undue delay.
Yeah, but then Hunter says that knowledge is a continual thing. So you can know of the evidence when, you can know it forever. And when is happening.
Yeah, I suppose you could say upon learning.
Yeah, Hunter explained it way better than I just did, but I got it.
Okay. I propose we move forward with the straw poll on the three options. Angela, if you could start that, I would appreciate it, because I'd like to have some time to discuss the comments, because I think there are several issues we need to have time to discuss.
Okay. Bacon.
C is none of the above.
Yes.
Yeah, can you restate 1, 2, and 3?
Option 1 is without undue delay. 2 is promptly, and 3 is nothing.
Okay, 3.
Brown.
1, undue delay.
Bradley. Chivers.
1.
Krieger, Mark,
Promptly.
Mercado,
1.
Munoz,
Promptly.
O'Reilly,
Without undue delay.
Poindexter, Star,
Without undue delay.
and Benola.
Without undue delay.
Okay, so that's 6 for without undue delay, 2 for promptly, 1 for nothing.
Okay, so could you add that language?
The other point, Chair, that I made that we haven't addressed, I don't know that you had it, was I said written in writing about this inform, the manner in which it's done. Is it known that it would always be in writing? Is that a given?
I don't believe, oh.
You all are citing other rules that cross-reference behavior, so is that?
I don't think it's a given that it has to be in writing. When the rules require something to be in writing, typically they state that, like, informed written consent is one example of something. So that is another proposal that if you is it your proposal, Raquel, that it should say shall inform without undue delay. Shall without undue delay inform in writing the state bar?
I don't know that you need to add promptly, because I'm not positive, but I think the way the intake office works is if you even get a phone call, they're going to say, well, fill out a report. So, fill out a complaint.
Joel, I think that you're correct. OCTC requires a written complaint, but I think that a lawyer may say, well, I called them and told them, and having done that, even though that would not allow, that's not how complaints are properly submitted, an argument to play devil's advocate could be made that they haven't done their full duty but have complied with the rule.
Well, don't they have a call log at the OCTC? I don't know.
So, I'm sorry, Eric, I followed you until the end, which I wasn't sure if you said they therefore had fulfilled their obligation or they had not.
So I don't know. I think a lawyer who called the state bar but did not submit a complaint in writing would make an argument that they had complied with 8.3.
But are you saying that the office will not investigate a complaint unless it is in writing? Is that the converse of your statement?
Complaints are required to be submitted in writing. They can be submitted electronically or in paper format, but they, as of right now, they are required to be submitted in writing.
But can't the bar can't an investigation be triggered internally? I mean, does there have to be a complaint? So why couldn't, you know what I mean? Like it could be triggered that way without there having to be a written.
Yeah, there are state bar initiated complaints, absolutely.
Yeah.
And maybe I'm misunderstanding, but it seems like this is a reporting requirement as opposed to a formal complaint that's being made against another attorney.
Right. So wouldn't it be like, on your My State Bar web, like where you have reporting requirements, like if you like reporting your malpractice settlement or something like that, it would fall under a different category. So are they going to add a link on the State Bar website, report on another lawyer? Do you know that, Erica?
I don't know. I don't think we're there yet as far as how, first of all, I'm not sure. I think there's a lot of things to be sorted out. One, who would receive these complaints? Meaning, would it be that they go directly to OCTC? Would they go to a different office? I think those are implementing steps, assuming that a rule
Going back-
instantly adopted.
Going back to 60680, it does say report to the state bar in writing.
Yeah, but I don't think we should put anything about that in this rule because it seems like something that the state bar will take care of as part of, the procedures on how to report that they will publish at some point once they figure it out. I don't want to impose an in writing requirement here.
I don't either.
And I don't know, I haven't carefully studied all the other versions of this rule, but it doesn't seem like there's a writing requirement for the other versions that I've seen.
Yeah, what the other bars are doing. Yeah. Same.
They might not want it in writing. I mean, I do feel like we should just defer and let them figure that out.
Okay, so
So Sarah, you asked me, did I want to put it in? It wasn't so much I wanted to put it in. I wanted us to have this dialogue about it. My advocacy for it would be that I think the seriousness of this role and the shift in behavior, and I think somebody described all the emotions around this. I think this is significant, and I think the idea of being very discreet, that it should be in writing. Because then I think it does, it has a higher standard. You need to really think about your commitment to doing it. What does it mean? So it gets in some way to the other side of Hunter talking about weaponizing. Because when you can just call and leave it and it can be anonymous and it starts going down a track.
Well, Raquel,
That is not the intent of this rule. So this rule is not for the frivolous, it really is for something that's important. So that would be the reason why you would say in writing, in my mind. So whether it's in writing because there's a form you click and you type something in, or you do an email or whatever. So that was, that's the thinking behind my saying.
Yeah, Raquel, on the other hand, you're talking about a rule that's going to be resisted by a lot of attorneys. They're going to talk about it being onerous and everything else. And maybe you're going to get more compliance if you just leave it, report to the state bar. They can pick up the phone, they can call, hold their nose and make their report. And then if the state bar tells them, well, put it in writing, they put it in writing or not, you might get more compliance as a practical matter without making it a formal in writing.
one other comment I wanted to kind of echo a little bit what Joel said as well is I do think that there might be more reporting and compliance, as Joel was saying, by not requiring it be in writing, not just because it's, might be easier to just pick up the phone and call, but also because attorneys might be concerned that by putting something in writing about another attorney, about potential retaliation, not that either complaint would be anonymous, but I still think the phone call option, it might be easier for an attorney to comply with, and the attorney might be more comfortable doing so by phone versus in writing. So in that respect, it would actually facilitate compliance with the rule.
And you could leave it to the OCTC to formulate their own intake rules or requirements on these kinds of reports, and might fine tune it at some point in the future if they want to.
Okay.
I mean, they have that for like, if under 60680, they have the various forms if it's judgment for fraud. I mean, I was just looking on the state bar website because I recall having to do that for a client of mine. So I think they'll eventually make their own form. So I agree with the other comments that doesn't need to be in writing in terms of the language of this rule.
Okay. So I understand from the people who have spoken so far, that Raquel favors putting it in writing, and others that I've heard from seem to be against it, but is anyone else in favor of adding an in writing requirement?
I just want to point out that, the ABA model rule doesn't have that requirement. SB 42 doesn't have the requirement. The Chief Trial Counsel's option C didn't have that requirement. So we're really jumping out there ahead of the curve if we go that route.
Yeah. No, I tend to agree. And as I pointed out earlier too, the other state versions of this model rule that I've reviewed have not had it. I think, since I'm not hearing others in favor of adding the writing requirement, I'm going to move on to a discussion of the comments to make sure we have some time to consider the comments to this rule. I guess I skipped over, to be honest, B and C now that I realize, but I don't think there was as much controversy about B and C from Brandon's report earlier. But just based on the public comments we've received, I understand there to be a few issues. One that was raised by several members of COPRAC and by public comments is considering a comment perhaps, or it might be part of the rule, we can debate that, where we clarify that an attorney's role in assisting or aiding one to obtain an abortion that might be illegal in another state would it fall under the scope of the rule's reporting requirements. There was also some discussion, Cassidy raised a suggestion earlier about incorporating the model rules comment about verifying what raises a substantial question means. And then the third issue that I noted from reviewing all of the public comments is that there were several individual public comments. In addition, the California Lawyers Association Legal Ethics Committee kind of questioned comment 6. And I think another bar association also questioned the comment 6, whether it should be in there, whether it should be removed altogether, or if it remains. It seemed that people wanted examples and clarification of when could a failure to report also implicate Rule 8.4a. So I'm going to pause there. I just wanted what I understood to be kind of the 3 primary comment issues based on my review, but I want to go one at a time. But before I do that, I wanted to first open it up to see if there were other kind of primary issues that people felt we should consider in connection with the comments, so I understand the scope of what we're addressing. And I'll start with Hunter, I see.
Yes, regarding the 2 public comments and the access to abortions, it occurred to me when I heard those, one, that we had definitely not contemplated that when we were drafting our proposed rules, but also that we probably didn't consider a number of instances where states disagree on what the law should be, and special interest groups are going to try to go after or might try to go after lawyers who are assisting people in any capacity. The one that really just kind of jumped up to me that's outside of abortions is, just marijuana law.
Mm-hmm.
You can practice California marijuana law if we have this issue of kind of the I forget what the term that was used. Let me see if I can find it. It was reciprocal discipline procedures. These reciprocal discipline procedures we have to consider. And so it could be that when we write a comment or something with regard to this rule, that we take into consideration when there are differences of laws, right? When there are differences as to what constitutes a crime, right? It would only be that which would be a crime in California, or would be fraud or basically anything that, I think we have to make it broader than just abortions, because at any given time, there might be hot button issues where California and Texas disagree on something. It's been known to happen. So I think that was, those comments were very poignant, but I think that needs to be even broader than the narrow issue that they presented.
Thanks, Hunter. And I agree. I had the kind of same initial impression of that. But I want to let others, what I wanted to discuss is kind of initial matter before maybe we can start with that particular comment, how we would draft that. But before we do that, just so I understand, because we only have until 4:30 to figure out what we're going to propose. So I want to make sure that I understand from a timing perspective before we get into a discussion of the comments. Is there anything besides the 3 issues that I've raised? Is there anything else that people think we need to address or tweak in the current comments, or add a comment to address without kind of weighing in yet on those 3 issues that I've already kind of raised? Because I want to go one by one and afford enough time to each issue. So Eleanor, I see you have your hand raised.
I do. When we have the lawyer should consider the applicability of other rules and comment 3, had we considered adding the duty of confidentiality?
Yeah, I think, is that not, we should put that as part of our discussion, but I thought that
I thought it was
the
too, but
body
I'm
of the rule already addressed it, right? Said it doesn't apply.
It's in paragraph C of the body of the rule.
maybe I missed it. I was looking for that and I just didn't see it. So
Yeah, or I guess now it should say C, but this rule does not require authorized disclosure of, and then it lists.
okay. Somehow I was missing. I thought it was in there. Thank you.
And Ken, did you have an issue you wanted to raise about the comments?
Yeah, well, yeah, without the 3, though I definitely had on the 3, but if we're not putting in the promptly in A, then I think we need to take promptly out of comment 3.
Okay. Okay, so I'll add that to the list of our items that we'll discuss with the comments. And I think I'm not seeing any other hands raised. I think that might be.
I did want to comment on comment 6, but I thought we weren't getting to that yet.
Yeah, no, and I think just because Hunter already kind of started the discussion on this issue, I think what we should actually, trying to think of a way to be more efficient. How about we work with, because it might be easier to do it this way, because I think it's going to be simpler to revise what's currently here as to the issues that are raised to the current comments. Then we'll work on potentially new comments to address both Cassidy's suggestion about substantial question and also the issue about clarifying that the rule doesn't apply to conduct that might be legal in California, but illegal in another state. Because that will take a little bit more time, but I do want to, I think what you just raised, Ken, as to comment 3.
Yeah, if we leave promptly in there, it's inconsistent with A because we chose not to put it in A.
Yeah, so we put without undue delay. So I'm looking at 3.
I think
Would you propose replacing promptly without undue delay then there?
Well, no, if undue delay is in A, then we don't need to have promptly or undue delay here, just your duty to report under A.
I see what you're saying, yeah.
So Angela, I think you can just strike promptly for everyone to read through to make sure that works.
I have a question, Chair.
Sure. Raquel?
So are we going to go through each comment, or are you suggesting only if people are identifying now that they want to say something on a comment, will you allow us to speak on it?
Well, what I'm planning to do, just because unfortunately we only have till 4:30 to present something, so I'm planning to go through these. There are 4 issues that have now been raised. And so I'm going to go through those 4 issues, and then if time remains, we can address other issues. So that's
Okay,
the
so-
plan right now. And right now we're focused on the issue just raised by Ken as to comment 3 and whether to remove promptly from that.
Okay,
And then I'm going to go one by one on the other key issues that members have raised.
Okay, so I want to raise one because I thought you said we were going to go one by one. and
Sure,
we
so
were
what-
only, so I want to talk about number 4. I do have some on number 4, so.
Okay, so that's the list then. Okay, so let's start with, so comment 3, does anyone oppose removing promptly from comment 3? Not seeing anyone, I'm gonna say let's move on to, since we're going with the current comments, let's go to 4. Raquel, do you want to raise your issue about comment 4 now?
Yeah, let me just say, it's more of a question to see if, this number 4 seems to be if you're in some kind of substance program and I hear something you're doing, you're exempt. Is that already a rule and there's no changing that? Is there any leeway in that? So that's a question because I don't know the rules or the codes of conduct.
So the statute regarding the attorney diversion and assistance program, what's limited to be disclosed under that is information that's provided to the state bar or to related individuals who assist with the lawyer assistance program. That information cannot be shared or disclosed. So that is the statutory limitation. The other language in that section goes beyond that. Does that answer the question?
I think so. I guess my concern is that seems like a big loophole. And I understand sort of the thinking behind it, but I'm not sure that is a protection I would want to have. But if it is one that attorneys have, then then it's a done deal. And so that's what I was trying to figure out.
Sure.
How much can we change? How flexible is that, given what already exists?
Yeah, so so you would need to actually change what's in or in paragraph C as opposed to the comment. Because the comment is just essentially stating the reasons for that exemption as opposed to the exemption itself. But what most jurisdictions that have adopted a version of 8.3 do is they exempt their version of a state bar lawyer assistance program. Sometimes they go beyond that where they have more than one state bar sanctioned, if you will, substance use or treatment program. So in California, for example, there's the State Bar's Lawyer Assistance Program. Another one that is commonly used by lawyers is called the Other Bar. So certainly, the exemption could be narrowed to either just be the State Bar's Lawyer Assistance Program or include, not AA, but one of these types of programs that is specific to attorneys. But that's the only one that I'm aware of that is very specific to attorneys in California. There may be others. I'll just say, having closely reviewed the public comments, there was only one individual who seemed opposed to having this be broadened to exempt any treatment, substance use or mental health program. And then 2 attorneys spoke in favor of having this exemption, just to give as much information as I have.
Okay, thank you. I'll think about what you said. Where else were you pointing me? You said paragraph C. Is that what you said?
Yeah, so what's in paragraph C, Angela, if you can scroll up, is the actual exemption. So it says the rule does not require authorized disclosure of, what's broadened here is information gained by a lawyer while participating in a substance use or mental health program. It could be limited to authorized or require authorized disclosure of information protected you'd want to, I'm assuming, keep attorney-client confidentiality and privilege, but you could just have the information that is confidential under Business and Professions Code 6234. That's the lawyer assistance program statute.
Okay, thank you. Thank you, Chair.
And, I have a question, Erica, correct me if I'm wrong. I mean, that exemption in 4, if I'm understanding it correctly, it's intended to things like if you're in a substance, the other bar or whatever, the lawyer's assistance program, and they're having like a group counseling session. And, as a member of that group, you hear that another lawyer did this. That's the purpose of that exemption, because without that, people would be reluctant to participate in these programs which serve their own benefits.
That's correct. So if it were limited to just those programs, that is exactly right. So lawyers participate in group facilitated meetings that have typically they're composed of exclusively attorneys or attorneys and law students and former attorneys. So without this exemption, there would be the statute that protects that information. But if it's not within LAP, which is the lawyer assistance program by the state bar, but like, let's say they participated in a similar program by the other bar, then an attorney who received that information. So let's say Ken and I were in a meeting together and I talked about all these crimes I'm doing. Ken would be required to report me, even if I was indicating in that meeting that it's because I have some sort of substance use issue. Obviously that's been expanded in this rule. So it would extend to AA, NA, those types of programs as well. What exists in paragraph C that if you're concerned about this, Raquel, we may want to consider narrowing is the rule says require or authorize disclosure, meaning that it says that you cannot disclose that information. And so you may want to just have it say require disclosure as opposed to adding that authorized language.
It might be helpful, Angela, if you could scroll up, because I think you're talking about language that's in the body, right, Erica? So we can see it.
Yeah, if you would need to make changes to what's in, I know it's showing as B, but what is C? And then you would make corresponding changes to the comment.
I'm in favor of leaving authorize in there.
Reading it, I think I agree. I think it's clearer.
I'll just add this. I also work with the Lawyer Assistance Program Oversight Committee, which is the appointed committee to oversee the Lawyer Assistance Program, and they have seen this language as it was proposed by COPRAC, and they are in favor of. They like it.
Yes, and there's so many public comments and I'm forgetting what I read, but I thought there was something too about just some public comments about really, I think these points have been made already, but just encouraging, especially in this attorneys to participate in these types of programs, and we wouldn't want to discourage attorneys from doing so. And so for that reason, I also am in favor of just leaving this as is, because I think it's most likely to facilitate participation. So does anyone, before we move on to comment 6, which is the next one, I want to see, does anyone feel that we should kind of remove authorize from the language of subsection C, which is showing it as B right now?
I don't, but I have another comment on that paragraph.
On paragraph
C or B or whatever it is.
Okay.
It talked about the lawyer contract, other applicable privileges or other rules or law. That the one thing I think we probably would have to put in there, be more specific than other rules or law, would be mediation confidentiality.
I can just speak to what was discussed at the working group unless one of the working group members that's here wants to talk about that.
Oh.
Bill, if you want.
Yeah, yeah, I think, and correct me if I'm wrong, Erica, but what we were talking about is, I mean, that's the whole point of having the phrase other applicable privileges. That's why we added, otherwise you could have a laundry list of other particular statutes that would provide immunity, such as if you're a mandatory reporter and, you know, things of that nature. So, because I was of the same mind with you, Ken, about the mediation confidentiality, because
But
I'm
it's
involved.
not a privilege, though. I mean,
It's not, it's confidentiality.
and
Yeah.
it is so specific. I think if we listed that one specifically, because that, I mean, mediations happen all the time and bad things
Right.
happen in mediations all the time. And, you know, they've got the, you know, Cassell case, you know, that deals with that whole issue. I think that one should be in there, and, you know, and then all the other garbage could be under the other applicable.
You know, I don't disagree with you, Ken, now that you're mentioning, because I know, I mean, you and I are probably the few who actually call it mediation confidentiality as opposed to a privilege. I know people get confused by that. It's not a privilege, it's just confidentiality. I agree with you. And I'm involved in the, you know, this California Lawyers Association ADR committee, and they were really up in arms about this. They want something specifically saying mediation confidentiality. And I think I would agree with Ken, actually, as we're talking through it, that we probably should add that, because it is in the case law confidentiality as opposed to a quote unquote privilege.
And yeah, and Bill, just, I know, you know, in addition to Ken, several of the public comments, including some of the bar associations, did recommend referencing mediation privilege or mediation confidentiality here, which I would support. But I do note that this rule also calls out or by other rules or laws.
Right, that's right.
So it is broad enough, I think, right now to cover it. But given that it seems like from the public comments perspective, this was a common theme about adding it, it's something that I think is worth considering.
I think other rules or laws, it's fine, it's a catch-all, but too vague. That's such a hot button issue, and mediations are so common now. I think that's one that really needs to stand out there in its own, just like Rule 1.6 and other things.
So
I agree, because I think, which I'm sorry, I didn't mean to interrupt.
No, go on, Bill.
Because I think originally that's what was my thought, because when I started to think about that and with this other group and they were mentioning concerns, I said, well, that's where, you know, it'd fall under the or by other rules or laws. But I agree with Ken. I think it should be in there specifically, so there is no confusion or misunderstanding that too is kind of an exemption, mediation confidentiality.
So Erica, you had your hand raised?
My only question would be is if Evidence Code 1129 is added, if other applicable privileges is still necessary at that point then, or if it's covered by other rules or laws.
I think I would still have other applicable privileges, because there are other privileges that are beyond the lawyer-client privilege that may be applicable. I wouldn't want to narrow it. I'd want to have a catch-all for any other things that's identified as specifically a privilege. So
it could
that would be my
spousal
concern.
privilege. You could have two, husband and wife, lawyer.
Right.
So I think, given time interest, I'm going to just ask, is anyone opposed to adding mediation confidentiality to this paragraph? So not hearing anyone opposed to it, I think, Angela, if you could add it, I think maybe it would be, trying to think where it would fit best.
I think it would fit best before the lawyer-client privilege. Otherwise, if you put it between that and the other privilege, it kind of wouldn't make sense.
That I think that makes sense as well. That's what I was debating. That works.
Do you want to just call out the evidence code, or do you want it to be?
I think it helps to have the evidence.
Yeah, I would add it.
So I think you could just put evidence code section, it's 1129,
Let-
right?
1115 et sec, I believe.
Okay.
ET, not ED. ET from home.
And then just to make it more complicated, and I think there's a period after et. And then,
Are we keeping in mediation confidentiality or just referencing the evidence code?
I think we should keep it in, but I will
Wait,
take
under?
colon. Mediation confidentiality, yeah.
I guess that if we did that there, why wouldn't you say a disclosure of attorney-client confidential information protected by
Yeah, you're
Business
right.
and Professions Code 6068E, just for parallel structure? I'm wondering if you just want to have it say evidence code.
Well, the parallel structuring would be mediation confidentiality and then lawyer-client privilege, because lawyer-client privilege has a specific code section, so.
Sure.
Yeah, there could be, yeah.
I think mediation confidentiality is fine.
And
I'm
then
I'm sure
the
we'll
E in
get
evidence
that.
and C in code are capitalized, Ange.
As we're looking at all this too, I have a very substantive question. How come my California and my official state bar background is facing one way incorrectly and Raquel's is the correct direction? I think I got a defective state bar background.
It's how you're viewing yourself, Ken. On my screen, you both show the same direction.
I
Yeah.
was gonna
okay.
say, tell public members from attorney members, we just turn the backgrounds.
There is
So
this, yeah. Sorry.
I'm not clear if we have a consensus on, are we just referencing mediation confidentiality, just referencing evidence code, section 1115 here?
I thought just mediation confidentiality without the code section.
So that way it's parallel to the lawyer-client privilege. Okay, so Angela, if you could remove under evidence code section 115 at sec, sorry about that. But I think, yeah. So let's now talk about, I think we should move on to talk about comment 6, which is the, so 2 of the bar associations, the California Lawyers Association, their legal ethics committee, and as well, I think it was Orange County Bar Association and some individuals, I believe too, didn't really understand comment 6, questioned whether it should be removed or clarified to provide an example. Questions were raised as how could a failure to report amount to a violation of Rule 8.4A, prohibiting, assisting, or inducing another lawyer's ethical violation. So the questions were raised about that, and the recommendation from the public comments was, if it's going to remain, it would be helpful to provide an example or clarification.
That's the one that jumped out at me when I looked at these comments, because there's already, if you have a duty as a lawyer to report somebody else's misconduct, you've now got your own violation that you could be investigated or disciplined for. But if the simple act of not reporting it now makes you, basically a co-offender for assisting, soliciting, or whatever, that's what that seems to suggest. So I think at a minimum, you'd need some sort of explanation in here that just the mere fact of not reporting does not make you a violator with the person for that actual conduct itself. You're only liable for not reporting it as opposed for the actual conduct.
Yeah, I agree with Ken. I recall a discussion involving the CTEP program, and somebody made the sarcastic comment, do you think Tom Girardi would have any trouble telling the state bar he had complied with CTAP when he hadn't? You know, I think that what we're trying to do is promote the kind of behavior that's going to get honest lawyers to do things to stop dishonest lawyers, and not make them automatically dishonest just because they for whatever reason don't seem to want to disclose what they see about someone else.
Yeah, the other just comment I have on comment 6 is generally comment 6 isn't really kind of clarifying the scope or nature of the rule. It's really alerting attorneys to, you know, this might violate another rule, but it would depend on the facts. And so, but we're not providing those facts, and so it seems to have caused confusion based on the public comments. So I question whether it's necessary to have this comment.
Yeah, Hunter, you could probably correct me, but I think under criminal law, if you observe a crime, you don't have to take any action to stop it, but that doesn't make you then a co-conspirator, co-liable for the crime. And that's what that seems to be suggesting. If you see somebody has done something wrong, if you don't step up and say something about it, you're now liable for their misconduct as opposed for your own failure to report it.
That's correct. The jury instructions for aider and abettor, co-conspirator and such do explain that failure to do anything about it doesn't mean you're part of it. Although it has occurred to me when reviewing this rule that there is a criminal statute that basically criminalizes you for not reporting if a firearm is stolen. Just the only time I can think of that you're really criminalized or potentially punished if you don't report a crime. So it's very, very rare.
I'm just thinking, I mean, Joel's the best guy at hypotheticals here, especially on the April listserv, but I'm trying to think of a situation where your silence would make you assisting. I don't see how it could be soliciting or I guess arguably I can't really come up with an example in my brain how your failure to report would make you assisting, soliciting, or inducing.
Well, Hunter makes a point that there is a specific statute that says you got to report a stolen gun because you have now been part of the process, I presume is the thinking, of a gun getting into general circulation in the population, which is dangerous. And you've got obligations to safely store guns and things like that. I don't think we have obligations to safely store lawyers to make sure they don't get out into the world. And I really think this just leads right into the why you're making us all criminals because of one bad apple argument.
Mm-hmm.
Raquel, you have your hand raised. Did you want to comment on?
Well, I have a question to the subcommittee. What was the thinking in adding Rule 6 or having Rule 6 be part of the proposal?
I'm sorry, I'm not understanding what.
So everyone is now speaking about why you wouldn't have it in. And my question is, we received this from a subcommittee who was proposing it be included. But my question is, just give us some context as to at the time you, like, why do you have it in here? So I just want to hear the other side. I'm hearing why it shouldn't be, but the committee had a
Understood.
reason. Yeah, had a reason for putting it in.
I don't have that background. I don't know if anyone from the subcommittee or Erica can provide that insight.
You know what? I don't recall. I really don't. I mean, the focus in the last couple of meetings had really been on the substance of the rule and not so much the comments. So Erica, I just don't recall how that came about.
I do briefly, but it hasn't been frankly discussed very much at the working group level. I believe this was as part of the staff proposed version. And I can speak to 8.4. I'll just say though that I think you may want to keep the 5.6b and 6090.5 language in a comment, and then consider just separating and removing the 8.4a language. I think, and speaking of Jill being good at hypotheticals, I think what was trying to be addressed here is that by failing to report, if you are in fact assisting someone else in violating the law or another version of another section of any of the rules, frankly. But you know, for example, I'm trying to think of a good example, but you know, you're not being the one to do the misappropriation, perhaps, but being aware of somebody doing the misappropriation. Although I think you could be violating other rules by in addition to 8.4.
I think we talked about this where, you know, you're all part of a conspiracy. I was just, and I feel like Hunter, I don't want to put Hunter on the spot, but we talked about how, yeah, if you're part of a conspiracy and you all agree not to report or something, there was a reason for it. And I think I don't remember.
The not report would be the 5.6 and the 6090.5 issues. I mean, if you reach some agreement, you know, that, you know, you'll keep silent, you know, or, you know, especially if you do so, like, okay, I won't report this, you know, if you'll throw in this perk on settlement or something.
Right.
That I can see, and that's why, you know, I think Eric was right about keeping those in. But, you know, getting back to Hunter, you know, and the gun thing, I mean, you know, once again, that's a situation where, you know, it's your gun. If your gun's stolen, then you've got some culpability there. But, you know, if somebody else does something that you have nothing to do with, simply not reporting that to the state bar shouldn't make you, you know, a co-conspirator, aider, or better, or otherwise responsible for that lawyer's conduct.
I'll just add that the purpose of the comments is to be, these comments is to be helpful in referencing a lawyer's other obligations under the rules to act or to not act. And so to the extent that this isn't going to be helpful, it doesn't preclude OCTC from finding a violation of 8.3 and 8.4a. It just would no longer alert a lawyer to that rule.
So I know we've had some feedback on this. Is anyone opposed to removing comment 6? Looks like Raquel. Oh, sorry, Erica, you had a
I was
question?
gonna say for clarity, are all of comment 6 or just the 8.4a reference? So the reference
to see how would it read? Let me see. What would your
you'd have to tweak it. So it would just be so the 5.6b and 6090.5 references relate to the fact that you can't agree as part of a you can't
oh yeah,
in the context of litigation agree to something that makes it so that they will not file a claim or a report of misconduct to the state bar. That's 6090.5. And then 5.6 says that same thing, essentially, that you can't offer or make an agreement that precludes the reporting of a violation of the rules. So it may just be using some sort of that language that exists in those two authorities, which would just say, you know, a lawyer shall not participate in offering or making an agreement. You know, you could just use the language in 5.6b and say, see 5.6B and B and P.
I understand. And
Or
I,
just flip it, just say with respect to the obligation, I'm sorry, the last clause of comment 6, you could just flip it with respect to the prohibitions on agreements, C rule, et cetera.
okay. Yeah, so if we were to do that, revise it as Erica was suggesting, would anyone oppose removing I guess the first half before the semicolon of comment 6? And Joel, looks like you have your hand raised.
Yeah, I was just gonna go there with what you said. I wasn't clear because I don't really know what the word implicate means, but implicate, as I was reading it, meant that if I just don't report something I'm otherwise totally innocent in, I'm implicated. So I didn't like that. But if you're going to take the whole thing out and just leave see also rule 5.6 and
Well, as modified, so it's clearer, but yeah, that would be the proposal. Okay, so I'm not seeing anyone from hand raises opposed to that. So Andrew,
I don't love it, but just because I think, again, in the spirit, but I would not vote against it if it's removed.
okay.
Would it be correct to say a failure to comply with this rule might be a violation of Rule 8.4A?
I don't think that addresses the kind of the primary concern that I've seen in the public comments, which that the question raised is how could just a mere failure to report, which would be a violation of 8.4, or I'm sorry, 8.3, also constitute a violation of 8.4A, prohibiting assisting another lawyer's ethical violation.
Yeah, that seems like the same thing, just in softer language.
Yeah, so I don't think that addresses the issue that was raised, at least. So that's why I was suggesting just removing this language altogether and keeping in the second half but modifying it as Erica suggested, the second portion of this.
Isn't it the other way around though? If you're a violation of 8.4A and say you're assisting, you can violate 8.4A, assisting another lawyer's ethical violation, and violate 8.43 because you know about that violation that you're assisting with, you're facilitating. So you've got two problems. I think that's where, that's where the conspiracy comes in, is that if you're participating in the conspiracy, you're violating one rule and you're also not reporting on your other co-conspirators.
And that's where this rule is typically where the discipline is in a other jurisdictions version of 8.3.
So is the reverse correct? Would we be correct in saying a failure to report by itself would not constitute knowingly assisting, soliciting, or inducing another to violate these rules?
Yeah, I think that's the problem. That's how it seems to read, but that's not the intent of this comment. Right?
Because the intent to be you're knowingly failing to report.
No.
No, I mean, so the confusion I've got is, one, the concern is if I fail to report, I'm basically helping them get away with this misconduct. We don't want lawyers to be held to that standard.
No.
So shouldn't the comment say failing to report would not? Do we have the authority to say that failing to report would not by itself constitute knowingly assisting?
Hunter and Cassidy, are you both suggesting we keep this language in and tweak it, just so I understand what's on the table here?
I think
I know we're running out of time. I just want to understand. I want to kind of get to the shape. I'm not going to be.
We're getting there, Sarah. We really are getting there.
Erica scared me because
they're saying the opposite. They're saying do a complete 180 of what's in the language right now. So they're saying a failure to report may also implicate. They're saying a failure to report will not implicate.
Well, I'm saying,
okay. I'm kind of confused. Okay.
Yeah.
But at the same time, just taking it out, if we just take it out, that it still may implicate, right?
Right.
Yeah, yeah.
Lawyers just won't be on notice of it, which is a problem. Like if it's going to be implicated, we want lawyers to know. But I would be in favor of tweaking this to say that a failure to report by itself would not constitute, solicitation. But
Or
it would have to be clarified as by itself.
If we're gonna go that route, because that's a fairly substantive statement, I don't think we can just plug that into a comment. That would have to be.
I think it would also need to go into 8.4 itself, not here.
Yeah, it may be beyond our purview. But I'm worried about taking it out. If it is potentially implicating 8.4A, attorneys need to be aware of it. I think the scary thing would be if it does implicate 8.4A and attorneys don't realize it.
So reporting equals assisting the violation that you're reporting, not reporting equals assisting the violation that you should be reporting.
If that's ever going to be used as a basis for
I hope not.
prosecution under the rules, then we'd want attorneys to know that, right?
Yeah.
We're not saying that it should be. We'd only be expressing that it could be, not because we think it should be, but because if it could be, attorneys need to be aware. And that's why I was talking about, well, maybe putting in something that says in our view, it should not be, but I don't know that we can do that. That's probably beyond our purview, but I don't think I truly appreciated the issue until Erica pointed out, I think it was Erica who pointed it out, if we remove a reference to a rule, we're not binding OCTC. We're not binding the rules. We're just removing it from consideration of attorneys who are trying to understand the rules.
I don't think we can go that far, Hunter, because 8.4A says, well, 8.4, it's professional misconduct for a lawyer to, and then A says violate these rules or the State Bar Act, and then knowingly assist, blah, blah, blah. So theoretically, I mean, if reporting is a rule and you don't report,
it's a violation.
It would be a violation.
But a substantive
duties under Rule 8.3, it just doesn't make you a co-conspirator, aider and abetter, or whatever of whatever that other person's doing.
Right, and that's why I was thinking something along the lines of a violation or a failure to report or a violation of 8.3 is not by itself assistance, solicitation, or inducement. So that it's clear that it may be a violation of the rules, but could we say, as we're constructing this rule, that it is not part of this rule, that failing to report is the same as assisting? Merely failing to report is assisting. So that's where my worry came from.
You'd need to put it into the body of, not in a comment, I think,
That
but
makes sense.
otherwise you could.
I vote for just taking that first part out and see Rule 5.6B and 609, that keeping the last part, because that does have to do with, active agreements not to report on each other, which is basically was the intent of this comment, I believe.
Can we just take a straw poll quickly on that proposal?
I'm in favor.
What is the proposal, Sarah?
The proposal
Yes.
that Cassidy made is to just remove the portion of this before the semicolon
And then tweak the next part.
and then tweak the
Make a
next,
complete sentence, but
which
yeah.
is what So let's, just to make it less confusing, Angela, could you take a straw poll?
Sure. So this is a poll to remove the highlighted section. Yes to remove, no to keep.
Yeah.
Bacon,
Yes.
Brown,
No.
Bradley, Chivers,
Yes.
Krieger, Mark, Mercado,
Yes.
Munoz,
Yes.
O'Reilly,
Yes.
Poindexter, Star,
No.
and Vanola.
Yes.
6 in favor and 2 not.
So I'm going to propose that we take a 15-minute break at this moment.
I second that.
And maybe during the break, Angela, if you could just kind of tweak the second, make the revision that we just did the straw poll on, and also tweak the second half
Sure.
that Erica suggested earlier.
Mhm.
That would be great if you're able to do that. And then we can resume at 3:30 promptly. That way we'll have an hour to get to the rest of this. Does that work?
Sure.
Thanks, everyone.
Okay, so what that shows is essentially just comment 6 inverted. So it's just the last clause that was there.
That works for me.
Does anyone have any issues or with it or revisions to it?
Seems like it needs some kind of few words before where it starts. It's just in terms of the way the other ones flow, this one seems to be missing something. Obvious because what was before it is now not there, so it kind of reads like the end of a sentence versus
Sure.
the right.
I'm not a huge fan of a lawyer may be disciplined for as the lead-in language, but that's what's used in a lot of the rules. So I guess you could put a lawyer may be disciplined for.
Do we really need to say that though, or?
And then you could say participating in an agreement that. I'm just floating language. I certainly think you guys can remove it or tweak it. And then it would be precludes the reporting. But yeah.
Do you want me to keep it for now in case we switch it back, or just delete it?
So it would with that, and then go to preclude that reporting.
It would be that, yeah, it would say a lawyer may be disciplined for participating in an agreement that precludes the reporting of. Sarah, just to catch you up real quick, Raquel wanted to add some language to the front of revised comment 6 to make it the sentence structure be more similar to other comments, I think, if that's inaccurate.
Okay, that makes sense.
I think if you did that, you'd want to have a period after rules. And then have it be capital C rule.
I have one suggestion. Should we say a lawyer may also be disciplined? To make sure it's just alerting them to another rule as opposed to something.
I was kind of going the same direction. I sent a little chat around, but I thought that some clarity on that might be useful. So I think it's another way to do it.
What is the clarity, Eleanor, by adding also?
Well, I think that the idea is that it's a violation of the rule as well as another rule. And maybe we can say it more succinctly, but that's the point from my perspective.
It's a violation of 8.3 and it's a violation of what's noted. Is that your point?
5.6. Yes, correct.
Yes. Okay. Thank you.
Okay, so I apologize if I'm late for returning, but I had a emergency with my daughter. But were there any other edits, or are we kind of done with this for now? The comment 6. I don't know if it seems like is everyone? I guess I'll ask, does anyone oppose comment 6 as revised? Hearing none, I think we should move on to considering developing a comment that would address the public comments and comments raised by some of our committee members on considering and clarifying that the scope of the rule would not include reporting of conduct of an attorney that might be criminal in another state, but legal in California. And the example that was provided is assisting someone in obtaining an abortion in another state where it might be illegal, but it would be legal in California. But there are other examples, as Hunter pointed out, such as in connection with counseling someone on marijuana. There could be other instances where it's a criminal act under another state's law or under federal law, but not under California law. So I'm not sure of the best way to draft that, but I do agree with Hunter. I don't know if you're still there. Hunter's suggestion to make it broader than just limiting it to aiding one in obtaining an abortion, although we could provide examples if we decide to include something. Does anyone want to suggest language? I'm a little frazzled at the moment to address that concern.
I mean, I understand and agree with the concerns about, reproductive rights. It might be too broad to say, I mean, unless I'm misunderstanding the rules as they exist now regarding criminal conduct, aren't limited to, California laws. I mean, you could commit a crime that in another state that goes, it's an act of moral turpitude or goes to your, ability to, or however they phrase it, your trustworthiness or fitness as a lawyer, even if it's not per se a crime in this state. I think we need to be careful. We just don't overstate that somehow. I don't know how we would target the language, but that would be a concern.
That's a good point. Erica, did you have a comment?
If no one else has language, I wrote something that we could start from and then go from there.
That sounds great. Thanks, Erica.
So I just think you could do, so I think you'd have to have it as a new paragraph within the body of the rule itself, not the comment. So my suggestion would be to make it a new paragraph B. And it would be the duty to report under paragraph A excludes conduct that would be a criminal act in another state. But not a crime in California. I think you have to narrow it to state. I don't know that you can resolve the marijuana concern with federal law violations just because of supremacy issues.
I don't think that's correct as a statement of law, though. Or as the rules currently exist. Oh, okay, well, I guess this goes to the duty to report.
Correct. It's
So-
just the duty to report. It's not saying that someone wouldn't be in a reciprocal discipline issue violating, 8.4, for example, or another requirement under the rules. What it would just remove the obligation to report it under 8.3. And then obviously, there's prosecutorial discretion for whether to prosecute somebody who assists with somebody who is licensed in California who aids in someone obtaining an abortion in Texas, for example.
And Erica, do I understand it that the reason we're putting it in the body of the rule is to make sure that we're not suggesting that's just how it is. We're saying in this rule in particular, is that why we're putting it in the body of the rule as opposed to explanatory? It's in the body of the rule that it does not include these things.
I think you can't have an exception
In a comment, yeah.
in a comment. It needs to be in the body of a rule.
Okay.
I just had a follow-up question. It was based on Ken's comment at the outset, which made me question, he's saying A is just saying a criminal act, period, right? Could we achieve the same kind of outcome by saying it in subsection A, a criminal act under California law? Or is it better to have this subsection B?
I think it's better to have the subsection B because one, it makes clear that we're making this distinction, and that demonstrates a clear intent by us to make that distinction. And two, A is already a little bit wordy. So just in terms of making it clear from a standpoint of the reader, I think having a separate subsection is a good idea. Although I would limit it to the criminal acts, because obviously maybe fraud in another jurisdiction, it would still be fraud here. So the duty to report criminal acts under paragraph A.
Yeah, Hunter, I'm trying to think of, because not my field, I mean, an example of a crime in another state. Obviously, the abortion issues have been raised, but, some sort of a crime that, setting aside reproductive or sexual rights would be, a act of moral turpitude, but for whatever reason, is not a crime in California. I don't know. I can't think of an example.
The reason why I want it to be broad is because in order to do that analysis, we'd essentially have to have encyclopedic knowledge of criminal law of 59 jurisdictions. And I don't boast that knowledge. So I would just say, if it's out there, if there's that potential, what we're really concerned about is criminal conduct as we see it in California, and fraud and misappropriation of funds. And that at least carves out the exception where we have these hot button political issues where states disagree with each other on these major things. Although for what it's worth, California tends to be less likely to have criminal sanctions where we are right now in the criminal law. So I think it's more likely to occur. Although we haven't decriminalized a ton of stuff, we've really kind of rolled back punishment. I think that this is going to age well based on the trends.
I guess I'm okay with putting it in there, and then we can see how the public comment feedback comes in.
Does anyone have, sorry, I think I was on mute when I was trying to speak earlier. Does anyone have feedback on this subsection B?
Would we want to, and this is, I'm not saying we should, but would we want a comment to this that basically says there are politically sensitive crimes that we don't want this rule being used as essentially a weapon in that war? And that's why we've got subsection B there. Because we started off the conversation with confusion about what is and isn't a crime. And when this goes out for public comment, people may go, well, hold on a second, this is even harder. Now we've got to be experts in criminal law from multiple jurisdictions, when that's really not what's intended here. So I'm thinking that we might want to have a comment where we essentially say, this is the reason we've got this subdivision.
Yeah, I see what you're saying. And I was thinking, I was questioning, the one question I had was somewhat similar to your suggestion, Hunter, was whether we should, provide some sort of examples as part of a comment on what we mean by B, including the examples provided this morning. But it looked like Eric, Eleanor, did you have your hand raised, or was it Eric?
I think it just kind of reminded me of if you've got a law where the constitutionality is being questioned, or if you've got something that's political, how do you exclude that from this? And you inject a lot of discretion when you do that, and I'm in favor of doing something like that or thinking that through, but I can see how others might not.
That's a good point.
Yeah, Hunter, in response to what you were saying, I don't know that I agree that this per se triggers now, oh yeah, now you got to know what's illegal in another state. I mean, I think the focus of this is you got to do to report crimes in California. Shouldn't have to worry about, you don't necessarily have a duty to report a crime in another state. Well, I don't know, now that I'm talking this through, I think this focuses on California crime. So if it's crime here, theoretically under A, if it falls within A, you got to report it.
So is that the what happens in Vegas stays in Vegas clause?
Well, if it's a crime in another state and a crime here, you got to report it anyway. But if it's a crime, in another state, but not a crime here, then this addresses that concern. And once again, I can't think of, most of the things you would want them reporting, theft, murder, stuff like that, is going to be a crime pretty much everywhere.
Yeah, and because you have that, and you also have the clarification that it has to raise a substantial question as to the lawyer's honesty, trustworthiness, or fitness. But I saw, Erica, do you have a comment? Your hand was raised before, but did it get resolved?
I'll let Raquel go first. My comment was in response to Hunter's proposed comment, but I'll let Raquel go.
Okay, Raquel.
So I was thinking of making the end the beginning. So something like the duty to report under paragraph A excludes conduct that is not a crime in California, yet may be a criminal act in another state. The reason I'm suggesting flipping it is I think people have made some points about the focus is if it's not a crime in California, so lead with what the real focus is, which is not criminal in California. And then the second part is just saying, hey, it may be because you also may not know. So the things that you know are criminal, but there may be, as laws change, it's something you thought may not be, or vice versa. So I'm broadening it to at least say may, but the main point is to flip it to what the real focus is, which is be focused on the crime in California. That's your responsibility as a licensed attorney in California.
I like that. Plus with the addition of the maybe.
It's going to have to get more complicated though, because you have to exclude the behavior that's not criminal. You've got to deal with the other conduct. I kind of am going back to, I think Cassidy suggested it, just saying committed a crime in California or engaged, if we want to make it broader, or engaged in fraud and misappropriation of funds or property, although.
One of the things
that should probably be under California law too.
One of the things that Eleanor, that you're saying is you're saying under California law, but we've actually done a delightful workaround of the supremacy issue by saying a crime in California.
Fair, that's fair, yeah, that's a good point. I would put it up in the first paragraph.
So
So
would it be,
Eleanor, you're suggesting that go in option A?
Yeah,
Is that-
yes. We move it
So
up.
so it would
How
be,
would
has
you,
committed
how
a
would you say
criminal-
it?
Yeah,
So it has committed a, what do we say, a crime in California? So that another lawyer has committed a crime in California as opposed to a criminal act.
Yeah, but I don't think that. Wait, has committed a crime in California? I think that's
So
just
that's the location of the
location.
crime as opposed to, but isn't that the same thing? Or, but it's
No,
not.
because you don't, don't
It's
you want,
committed an act that is a crime, a fraud, misappropriation in
Right.
California. Okay, so, but either way, I think getting it phrased right, we can work on, but I would put it up in A because I just think it's gonna introduce a lot of complexity if you don't.
If I'm a California bar member, but I live in New York, do I have to report a crime I see?
in New York, yeah.
so what if it was a criminal act? It's gonna be very wordy in A, but it would be, has committed a criminal act that constitutes
Right.
Act that.
a crime under California law, essentially.
Could we,
No,
It would
because
be
federal
if
law
it's
is included there too.
jurisdiction. So the location it would address the location that way you're. So
Yeah,
you have the
maybe it's a
supremacy
good
issue
point.
and then you have the location of the act,
It shouldn't matter where the crime is committed,
right?
because.
yeah, I agree, but was there I thought initially I had suggested under California law. But it sounds like, or and Erica's saying that constitutes a crime under.
I think the concept we're getting at is where there's a divergence in California controls.
Right.
Oh, I see, but that's really hard to
It is.
address.
Yeah. That's why we make the big bucks.
Yeah, I'm thinking of somebody who's got dual bar memberships in California and Texas.
Yeah,
I mean,
this
we
is,
could say something like if committed in California would be a crime, but if,
this is gonna raise some issues.
Because federal law is also overlaying everything as
Oh,
well.
gosh, and now federal law, yeah, you're right.
Which is why I like saying it would be a crime in California, because
Yeah, I
federal crimes are crimes in California too.
Right.
I like that construction more and more.
I'm getting a little, I guess maybe I'm not understanding the issue is quite clearly, so I just want to clarify. So we're doing this because we're concerned about the supremacy clause, is that?
So,
I don't quite understand, because it seems like if we're just talking about a reporting requirement under California law, I don't know how we implicate the supremacy clause. I think I'm kind of confused on that.
So I think what we're trying to say, or Hunter, go for it.
Well, it occurs to me that if you see a member of the bar smoking marijuana, you've seen them committing a misdemeanor, you've seen them committing a crime under federal law, but not under California law. And so we're trying to avoid any reference to a supremacy issue because that's really not where we're going with it, right? What we're worried about is warring jurisdictions where one of them wants to impose their cultural-based legal decisions outside their borders. And the comments this morning showed us that can be done in at least one area. So I think saying the duty to report, criminal acts under paragraph A, I think just summarizing it as if it would be a crime in California, but not elsewhere. That's where it ends. I don't necessarily think that takes care of the supremacy clause. But what it does is it does not exclude the possibility that you see somebody commit a federal crime and you think you can't report it because it's only crimes under California law, or think you shouldn't report it or something. So if we just say crimes in California, it keeps that open.
But Hunter, you just raised an interesting question, not to make it more ambiguous, but marijuana is illegal under federal law in California.
Yes.
So do I have a duty to report?
Um,
If the conduct raises a substantial question as to that lawyer's honesty, trustworthiness, or fitness.
or fitness.
Now we're
for-
off to the races again. That's the cultural question.
And that's why I think it's so important to have that, because you run into these little kind of unanticipated things where, and Cassidy keeps coming back to it, we need to have that level of professional judgment where we can incorporate the level of professional judgment. But with this one, we're really trying to tailor the exclusion to those situations where they're trying, where somebody might be trying to influence conduct that for whatever political hot button reason, they're trying to, push the influence of that. And the most obvious, and apparently the one that's happening right now, example is on abortion. But we have these all the time in this country. And if
But
we
so
have-
this, as written, this subsection B would not capture the marijuana question or like assisted suicide or something else where a state had. But take marijuana, because it is a crime in California under federal law.
Right.
So that wouldn't be included in this exception.
It would not be, it would be dealt with in the body of the rule regarding substantial question. So
Okay.
we've got the protection of those ones where there are divergence between federal law and California law. I think that's taken care of by the professional judgment caveat. This one,
And also, it's not to complicate it, but we've got that advisory on advising a cannabis business.
Right.
Let's hypothetically, let's assume the person we're advising who's forming a cannabis business and the lawyer is going to provide that advice is also an attorney. Do we have to now report them in contradiction of what we've already said in our ethics opinion? It's, I don't know the answer. I'll defer to Hunter on this. How's that?
well,
I
I
can
mean,
prosecute.
I think it keeps coming back to when there's a discrepancy between federal and California law, it does create all kinds of problems for California lawyers, just in general. And so this raising a substantial question as to their honesty, trustworthiness, or fitness, I think really deals with those discrepancies. But and frankly, it may deal with the other ones as well, to some extent, but
I think the answer, Hunter, is that we can't affect that delta between federal law and California law because of the supremacy clause anyway.
Right. We can't, but we can affect the state to state stuff.
Right. Yeah. So I think that's why Erica drafted it that way. That makes sense.
But if we say under California law as opposed to in California, we do appear to be weighing in as to the application of federal law. Because we're by stating that we are excluding the application of federal law, and I don't think that's appropriate.
I agree with that. Yeah.
I just want to weigh in for briefly, because I'm still kind of, I guess maybe I'm alone here, but I still don't understand how by drafting a rule that has in California that has a reporting requirement to report when a lawyer has credible evidence that another lawyer has committed a criminal act under California law, how that implicates the supremacy clause, because that does not conflict with federal law. It's not saying it's not a crime under federal law. It's not undermining the federal government's ability to prosecute for a violation of that law. So I always understood the supremacy clause as implicating, policies or rules that undermine or conflict, state policies or rules that undermine or conflict with federal law. And I don't see how this would undermine or conflict with federal law.
That would also be consistent with you don't have a duty to report a crime in general as a citizen. We went through that earlier.
So let's take hypothetical federal statute X, and
RICO violations.
You're aware that somebody's violated this law, and it does raise a substantial question. right? Should you be required to report that, even if under California law, it's not a crime, but it is I mean, it's a crime and it's fraud under federal law. Or maybe it's not fraud, but maybe it's just a statute, a criminal statute that you feel raises the substantial question. That should be covered by this. By referring to California law, it's technically narrowing the scope and not taking any of those crimes that would be crimes under federal law. So it's not that we're nixing federal law. It's what our rule would include potentially violations.
Yeah, I understand that point, Hunter, but I still don't understand how the supremacy clause is implicated. That was my concern. I understand that point that you're making.
Only to the extent that we're not saying that the delta between federal law and California law, you should follow California law, because that's the opposite of the supremacy clause.
Right.
So we've left that out by design.
Yeah, when there's a discrepancy, we're not gonna pass on that. We're having some purposeful silence with regard to any discrepancies between California and federal law. Those things can be worked out separately.
Yeah, but we're not opining on what's a crime under federal law.
Right.
What is it? It's just limited to reporting. So I'm very confused.
But the duty to report is based at least in part on it being a crime. So
yeah.
Okay, I sent some comments around if folks want to look. I think we can eliminate some of the confusion by getting away from the duty construction and just going to a definition of crime and defining what we mean by criminal act. So that we cut out the overlap between criminal act and the other enumerated conduct, fraud, misappropriation of funds, which might also be criminal acts. But for me, that was part of the hang up in this construction for C.
So Eleanor, would it be something along the lines like what we did before for as used in this rule, or for purposes of this rule, criminal acts includes?
Yeah, so it was, yeah, for purposes of this rule, criminal act shall mean conduct that would constitute a crime in California, or rather under California law.
That would seem to take care of it.
I like that.
I don't know enough about the difference between federal criminal law and California criminal law, but are there like, I'm thinking of like RICO. Is there a California RICO equivalent?
We call it baby RICO, but
okay. But are there other, really bad crimes in the sense that we would want them reported that don't have a state counterpart?
So the primary distinction is a lot of federal crimes have jurisdictional requirements, like a jurisdictional hook, like using interstate commerce or taking somebody over the border to do certain things. Whereas in California, it might not be, and I don't know because I don't do this kind of prosecution, but it may not be a crime to take somebody out of state to do something lewd with them. Although I imagine that probably is illegal. But as an example, you may have federal statutes that are designed to prevent that specific thing.
Depends on who the person is, but yeah, go ahead.
And so when you've got a federal statute, and the point is that they're both federal and criminal laws are federal and California criminal laws are expansive enough that I think it is well within our contemplation theoretically that statutes exist under the federal code that don't exist under California's code that would fall within the ambit of mandatory reporting as we perceive the need for it.
So that would weigh in favor of keeping only the limited state to state exception, as opposed to removing federal from something that must be reported.
Well, I think by defining a criminal act means a conduct that would constitute a crime in California does not foreclose the reporting of federal crimes because of the way it's phrased.
Does it not foreclose it, or does it still create a duty to report them?
It does not foreclose the duty to report. So if there is a crime under federal law that is a crime in California, then you still have the duty to report them if it raises a substantial question. If we say under California law, we are removing the duty to report those violations under those statutes.
I think that is going to be confusing for the average lawyer, personally.
What part of it? I'm realizing as I wrote, like the third paragraph was actually misconstrued, but what part of, like, if we just went criminal act shall mean conduct that would constitute a crime in California, how is it, what confusion does that introduce?
I don't think that some lawyers are going to realize that includes the reporting of federal crimes.
I see.
But that's just my take on it. I could be the only one. Ken, you're on mute.
It says another state. So it's not talking about federal law. I think there's a reasonable interpretation of that.
Are you looking at, I'm confused.
He's
Are we
talking about A, I
considering
think.
what are we considering now? Are we considering I thought we were considering Eleanor's suggested language in the chat.
Angela, can you put what's in the chat on the screen? I think that would be helpful.
Just the first paragraph.
Oh, we're talking about something else. Oh, okay.
I think Eleanor's solution would work, actually.
So it would be as, for purposes of this rule, criminal act shall mean conduct that would constitute a crime in California.
Well, we could say more. We could go on to add clarifying.
That is a question, I mean, that I asked before, but it is that if I'm in another state and I see somebody committing a crime, do I have a duty under these rules to report it? And if I'm a member of the California Bar, or is it excluding only when there's a divergence between California law and another state's law?
Well, it's only a criminal act by an attorney that you'd have a duty to disclose.
I know, I mean, by an attorney.
Oh, there are some interesting differences in jurisdictions regarding ages of consent.
I guess I share, I don't know if I was understanding this, but I do still share, I think, Erica, you're the one who referenced this, but that I don't know that I would necessarily interpret this to mean an attorney would have to report a violation of federal law that's not a violation of California law. I don't think that's for me, that's not reason. I don't reasonably interpret this language to mean that.
I mean, ultimately, we get to make that call. I think when we define what the ambit of the rule is.
Well, we could add more clarification to this to clarify that. Because I don't think we mean it's just conduct that would constitute a crime in California. We're also, if I understand what others are suggesting, we're also saying that you'd have to report conduct that would constitute a crime under federal law. So isn't it under California or federal law?
If we were going to use the terms of under the law of X jurisdiction, yes. And
I think all of this is too limiting in the sense that all we're trying to accomplish is removing where there's a state jurisdictional dispute between laws. So be it, a Texas abortion law or, something else, but the abortion law is a great example. That's the only thing that unless you are trying to narrow option A or some paragraph A more, I think that's the only thing that you are trying to exclude from this rule. I don't think you are trying to exclude other state law violations necessarily that are slightly different from, but substantially similar to California state law violations. Because I think that I think would be very complicated for people to figure out. Meaning, you know, if it's a crime to do X, Y, and Z in Missouri, but you have to do X, Y, Z, and A in California, that I think will be hard for attorneys to determine without doing a lot of research.
Which gets back to my recommendation of a comment that basically clarifies, this is about dispute, like culturally based disputed criminal laws that are going to cause problems and be weaponized from jurisdiction to jurisdiction. Topics like abortion, firearms, there are just some really major ones out there where states are not cordial with each other when it comes to those.
I think that would create, I mean, I don't disagree with you. I think that would create a lot of flack. I mean, the definition that we got there seems to fit in, because once again, this is only the duty to report. It doesn't exclude reporting, or you know, anybody could report any kind of conduct they think a lawyers did that may violate some other state's law or whatever. That's up to them. This is just talking about the duty of what California lawyers are obligated to report under this rule. That's limiting it to crimes in California, and then further qualified where the conduct raises a substantial question of lawyers' honesty, trustworthy, or fitness, blah, blah, blah.
If my only comment is if the intent is really to address the concerns raised by the public comments and include in the scope of the reporting requirement criminal acts under federal law, I feel that the proposal that's showing on the screen as C better accomplishes that goal. But I don't know.
My biggest problem with that is that it says it's the construction of the duty to report criminal acts, because I think that captures conduct you're not intending to capture. So, or it creates confusion where fraud, misappropriation of funds or property might constitute a criminal act. You actually don't want them subject to this. I think what you're trying to do is define what you mean by the duty to report the crime, as opposed to modifying the duty. You're trying to define the term. So I think we should change it.
Could it just be for purposes of this rule, criminal acts as used in paragraph A excludes conduct that would be a criminal act in another state, but not a crime in California?
I think that would work.
And the other suggestion I thought of, Eleanor, in response to that, is maybe we could put criminal acts in quotes to further clarify.
I relate to what Eleanor said, and I think Angie's typing versus putting it in the comments. So I think I not put it in the comments. If we wanted to have a comment, I wouldn't tie it with political, with some of the commentary you said. I would just state whatever the types of things we're talking about, but not introduce that it's political. Because I don't think it adds to the understanding of what the comment is meant to do, and in fact can be distracting.
Yeah, I understand what you're saying. So Kelly, you would just provide the examples of the type of
Or
conduct in the
yeah,
comment.
I mean, I think Hunter made a larger statement. He just prefaced it with the political, but I think he made a complete, at least one complete sentence, maybe two.
Okay, so before we get to a potential comment, I want to see if we can get some consensus on what's showing as C or as an alternative, B, where we would be defining criminal act. So maybe I'll start with C, because it sounds like Eleanor, maybe with these revisions, you're more comfortable with C. What do you think, Eleanor?
I mean, for purposes of time, I think I am getting comfortable with C. I like that. I think I might have a slight bias for the other construction, but it's not there yet. So, and I think C does what we needed to do, but I'm wondering, should we say state or jurisdiction as opposed to just state?
But then by saying jurisdiction, are we including federal law? That's
And
what
international law too.
and I didn't think we were intending to address, provide as part of the.
But
like,
wouldn't it be the
exception.
same? Wouldn't it be the same analysis though?
What are we trying to include, I guess? So Washington, DC.
Is another jurisdiction?
Well, DC is the first thing that came to mind, but I think you might go broader.
What about
Right.
Puerto Rico?
Yeah, so exactly. I think we're trying to territories.
Right.
And so DC and Puerto Rico, I believe, are both and Guam, et cetera, are territories. So maybe that covers it, but you are exempting international law. But I mean, again, there's just a lot for a lawyer to know.
As long as I don't have to know the rule against perpetuities, I'm okay.
So would it be in another state or territory?
I think that works. What do others feel?
Well, I mean, you
If
can say,
DC is a territory, I don't know if it is a,
I just Googled it. This.
oh, it is. Good to know.
Well, if Google says it is, it must be.
Exactly.
It's true.
Right.
does territory include foreign though? I mean, do we want to include foreign? Because otherwise I think you would say US territory, right?
Sure.
So don't we want to include foreign, like,
Getting back to
We
the,
want to include foreign in the excluded.
I was gonna say, getting back to the old law school analysis of a negative pregnant. If we don't exclude foreign,
right, then it's included.
Yeah,
Yeah.
You
and
knew
then,
how to exclude
you know,
things,
you're-
but you
somebody
didn't.
commits-
jurisdiction works. I mean, I think it actually.
I know, but then we're running up against the federal issue,
Would you say in another state or jurisdiction except
federal?
I
except
would
federal?
accept it, but argue that the supremacy clause means it actually is a violation in California. And then you get to the heart of the argument. We don't need lawyers making this, like it creates, we live with the ambiguity that people argue about all the time.
Good point. Or you can just say in another state, US territory or foreign jurisdiction.
Yeah.
That actually, I mean, that does avoid it.
Hint, hint, we still include federal.
Then would you say US state? If we're gonna say US territory, just to clarify.
I think, well, I think, maybe, I think what the other, when territory is referenced in other rules or statutes, it's US territory, but I don't think state is. Because United States, I don't know,
I don't think we need to say.
US state, yeah.
States now. I think we just say
that
states.
is clear.
So what is the quotations around criminal acts? I think Eleanor, you proposed that.
It's referring to paragraph A.
Yeah, I think it's,
Is that why you're saying, okay, thanks.
yeah, it's calling out that phrase.
Okay, thanks.
Although in A, it's in the singular.
Oh, maybe we should make it singular here too for consistency then. Just so we have some time to consider the comment to this subsection that Hunter and Raquel talked briefly about, I want to just check it. Is anyone opposed to this subsection C as showing on the screen now? So not hearing anyone, I think we should talk about a potential comment to provide examples of what we mean by subsection C of the rule. And Hunter, I think you had proposed some language and Raquel had suggested that perhaps not using the term political or politically motivated as part of the comment. But you want to suggest something as a starting point, or does anyone else have suggested language ready to go that they could?
This is providing examples of what we just added in B.
Yes.
I don't know if we really need to go there, do we?
Yeah, we might not. I mean, that might be that people feel it's unnecessary. If that's the case, I don't know that it is actually necessary.
At this point, I'm okay with adding that subsection we had. We don't necessarily need to add additional comment. And if the public comment feedback warrants it, we could always add a comment later on.
I agree with that.
Yeah, that makes sense. Does anyone feel strongly about adding a comment?
Not at 424.
If not, I think we might have time to very briefly address the last item, which was Cassidy's suggestion to add, incorporate the ABA model rules comment that clarifies what is meant by substantial question. And I'm not seeing, oh yeah, sorry, you're dark, Cassidy, but I see you now. For some reason, it's your background. But was it comment 3 to ABA model rule?
Yeah, I put it in the chat. I don't know if you guys can see that. And I think it needs to be tweaked. So I don't think it can be cited or stated verbatim.
I'll send it to you right now so you can put it on the screen.
Great. And just as you're doing that, I just have a quick question for everyone who's left. Is everyone okay maybe saying 10 minutes over if necessary so we can just vote? Or do we need to conclude promptly in 5 minutes?
Oh, is it? Wow.
I propose 9 minutes extra. So.
So if anyone needs to leave, let me know now so I can, but if not, I think we could at least consider this comment and then proceed with a vote.
And if you'd like, just so you're aware, you can direct staff to clean it up in the sense that I think that there are, it may be missing the appropriate subparagraph because of the formatting currently, but we can do that.
That makes sense. Thank you.
So on the comment, I think the first 2 sentences, I think can be removed. And then it should start with this rule. Limits the reporting obligation to those offenses that a self-regulating profession must vigorously endeavor to prevent a measurable judgment. So these are the 2 key sentences that I think are important. And then I don't know about the last 2 sentences. They're kind of not relevant.
Yeah.
I'll just say in response that we had some questions about I know that substantial is new, but the personal knowledge, I think it might be helpful to have the term substantial refers to the seriousness of the possible offense and not the quantum of evidence. I think that is helpful to some.
Yeah, those 2 sentences should, starting with this rule and the term substantial, those 2 sentences, there's 3 sentences. The first 3 sentences should stay in. And then I think the last 2 can be removed unless we feel they're important. Wait, hold on, don't remove them yet.
The second to last sentence, we are actually, so the rule, paragraph A directs people to make the report to the state bar. So it's not necessary like it is in the model rule. And then we don't have a judicial misconduct reporting aspect of this rule. So neither of those 2 sentences are needed.
Is
Okay.
is there a circumstance when we should say you don't have a duty? Like, for instance, there's already a legal action, or there's like you're aware of a complaint or a bar action, or like, you know, some circumstance when you wouldn't have such a duty, want to put in here?
I think that is an exception, right? Then that would have to go in the body and it'd be another consideration than part of this comment if you're saying if it still falls within the scope, but just because it's being already.
It does seem like there would be circumstances where reporting would be moot. And you should,
If the lawyer knows is all the conduct's already been reported to the state bar.
it's known, it's publicly known, there's a legal action, something.
So from the public protection perspective, there's no downside to getting more reports on the same misconduct. The downside is the attorney having to actually make the report.
Yeah, so can we maybe table that consideration? Because I don't think that, at least in my mind, that doesn't fall within the scope of this comment 3, which is intending to clarify substantial. And just, I think right now, I believe everyone's in agreement that we should remove these last 2 sentences, which don't apply to our California proposed rule. So we could remove that.
Mhm.
And then does anyone have any concerns with comment 3?
Only that rule, I think rule should not be capitalized because I don't think we capitalize rule everywhere else.
Another California diversion from the ABA.
Okay, is anyone opposed to this comment? Not hearing any. I know we're close to 4:30. Eleanor did raise one final issue, although I think that would require some consideration. I'm not sure if we really have time, but if people feel it's important, I'm willing to stay on and discuss it more. I know it's 4:30 now, so, or almost, which would, I think the proposal would be to, and Eleanor could probably explain it better than me, but to make an exception to the extent the reporting would be moved because it's already been reported to the state bar and the attorney knows it. I think that might be kind of difficult to draft at the last minute, but I'm open to discussing it further if others want to.
I think adding it might be problematic at this point. I mean, if we approve this, where does it goes to out for public comment, it goes to the board, where does it go?
So then just my understanding, and Erica can clarify me, but is that whatever we propose here, it will go to the Board of Trustees, and the Board of Trustees will consider our proposed rule, and they could further revise it or suggest something else. And then that rule that the Board of Trustees approves at their next meeting, which I believe takes place I forget when it takes place.
March 16th.
March 16th. So after that meeting, they will have approved some version of the proposed Rule 8.3, and that would go out for another comment period, public comment period. And COPRAC wouldn't be as involved from that stage on. So whatever we propose, our best proposal for the Board of Trustees to consider further, so they could still tweak it more.
Could we put when we transmit it to the board that, we considered an exception for, known, just.
That's a good way to address it. Yes, we could certainly, in our memo, we can talk about some of the issues discussed. So that's a good way to address Eleanor's concern.
I like Hunter just jabbered, or rather texted something to the group too, which I think is useful. Or I would be in favor of adding something like that.
Yeah, to incorporate, that makes sense. So at this stage, I would propose that what Hunter put in the chat, that we note that, we considered this, but didn't have sufficient time to thoroughly discuss it, and we ask that they consider it. Or in kind of the forwarding letter that goes Is that what you were suggesting, Ken?
Yeah, just from a time standpoint.
Yeah.
I'm okay either way, but we haven't really had a long time to debate that, so.
Yeah. Okay.
Sounds good.
Okay. Thanks, everyone. So I think at this stage, I would ask if someone would like to move the revised proposed rule 8.3 for forwarding to the State Bar Board of Trustees for their further consideration, subject to any kind of minor edits that State Bar staff would make to kind of clean it up, any typos or any like updating paragraph numbering and stuff like that, formatting type issues that we would, if someone wants to move to approve this revised proposed rules for further consideration by the State Bar Board of Trustees.
I move that we accept the rule 8.3 to be forwarded to the Board of Trustees and allows the staff to make minor formatting adjustments.
And thanks, Raquel. And one thing I forgot to add as part of that motion, and I don't know if you want to add this, Raquel, because we had just discussed it, which was also to include in the cover what is showing on Hunter's chat, which was based on Eleanor's suggestion that we also considered this issue, but did not have time to reach a consensus on it.
Yes, I will accept the friendly modification as Chair stated.
Thank you.
I'll second.
That was
Okay.
Ken.
Yeah.
Thank you.
Taking the vote, Bacon,
Yes.
Brown,
Yes.
Bradley, Chivers,
Yes.
Krieger, Mark, Mercado,
Yes.
Munoz,
Yes.
O'Reilly,
Yes.
Wayne Dexter, Star,
Yes.
Benola.
Yes.
So the motion carries.
All right. Well, thank you to everyone for staying past the ending time. And I know, unfortunately, we didn't get to address all the other items on today's agenda, and I know we have to all go. It's Friday, but I do want to at least mention very, very briefly the ethics symposium that is coming up, because I think we're a little delayed. People who are going to be moderators this year in kind of finalizing the panelists for the panel and the description of the panel. That deadline was, I think it was February 27th. So if we could try to aim to get that to State Bar staff early next week, that would be the goal. And also, perhaps after this meeting, we can follow up via email with what the final panels are, so everyone knows, because it would be great to have everyone's input and who the moderators are. So if anyone from the group wants to weigh in and suggest who they think would be an amazing panelist, that would be helpful too, to get some feedback or input from everyone. I just don't want to keep everyone too late. I would love to do it now, but I think we can do that via
Make a 30-second one. I'll make a
Ken,
real,
what were you saying?
I can make a real quick one.
Sure.
I'm moderating the panel on AI and the law. And a number of potential speakers I've contacted have conflicts on that day. I reached out to people who are on the old, the ADL subcommittee on this, and they're hard to contact. So if anybody has any suggestions of potential speakers regarding AI and the law, chatbots, I would appreciate if you let me know.
I do, Ken.
Oh, great. Thank you. Yeah,
I might also have someone for you, Ken.
okay, yeah, if you guys shoot me an email, I would very much appreciate it.
Yeah, and just the other panel that I think, Hunter, you're taking the lead on is an implicit bias and civility. And the final panel is Joel is moderating. I think it's lessons learned from Girardi. And then there will be the leadership panel on recent developments in legal ethics, just so everyone knows. For that, it's just leadership. So for those other 3 panels, if people have suggestions, you could reach out to Hunter, Joel, or Ken.
I'd actually really appreciate it if you could. The idea that I have for implicit bias is actually bringing in panelists to discuss how their firms or their practices are implementing changes to actually combat implicit bias. And I've got some ideas, but I would really, if you have a line on any of that, I'd really appreciate it.
I'll just add that because I've been working with Joel, Joel has the panelists he needs, so he doesn't need any additional recommendations for panelists. So if you have them for the AI or implicit bias one, I think that's where they're needed the most.
Thanks, Erica.
Hunter, is yours in client facing or internal facing?
So a little bit of both. So from the prosecution side, I'm going to be reaching out to the prosecutor up in YOLO, the elected DA, who a couple of years ago enacted what he calls blind prosecuting. It's a major program that he has there that is designed to remove implicit bias from charging, but it would be from all aspects, whether it's efficacy of implicit bias training, or whether it's hiring, working with clients, whatever the case may be, instituting policies in the practice of law that are aimed at this and how effective they've been.
Thanks.
Okay, well, great, everyone. Have a great weekend, and I'm glad that we were able to reach consensus at the end. I think we had some great suggestions, so thanks again.
Thank you.
Thanks. Have a good weekend.
Have a nice weekend.